Welcome back, everybody. Is Ms. Just trying to go around my screen. Is Ms. Sheard there?
Yes, I am.
Right. Oh, there you are. Found you. Sorry about that. Are you ready to?
Yes, assuming Mr. Swears has made his way in.
I'm just trying to spot his name on my screen as well.
Yes, I'm here.
Oh, there he is. Now he's here too. He's just got a different name on his popping up on his screen, so I couldn't quite identify him. All right. Well, if you could turn the recording on, Mr. Bell, and we'll resume. Thank you.
Yeah, I believe the recording's gone. I'm going.
Thank you. Thanks, Mr. Swears, just when you're ready.
Thank you, Mr. Mitchell. If it works for you, sir, I'd just like to go through some of the points in my summary statement. So I'll just highlight a few of those and then leave it open for you to raise any questions you might have.
Thank you.
Just starting at paragraph 3.1 of my summary statement. So the applicant's proposing a series of compromises to transportation standards, guidelines and principles in order to accommodate the proposal, and I'd just like to highlight a few of those. So first one, we've had discussion about this already this morning, using an interregional arterial for local trips. The rezoning is reliant on Huntly to provide for the land use activities that aren't available at the site, and workers at the site who don't live at the site will need to use the Waikato Expressway to travel to and from work. Paragraph B under 3.1, they're creating the potential for active user journeys, but they're positioning the proposal at a location so these journeys are unattractive. So firstly, the walking journey from the site to the school is approximately twice the average distance that children walk to school. Over the page under item 2, the cycling distance from the site to Huntly is approximately twice the average that people cycle to work. And just picking up on a comment Mr. Cooney raised yesterday in relation to the cost of e-bikes, while e-bikes may make the journey from the site to Huntly more attractive, those bikes aren't necessarily a cheap mode of transport. So paragraph C, item 2. So in terms of some of the roundabouts that are being proposed, these are smaller than the minimums described in design guides, but the applicant hasn't provided any justification as to why small roundabouts are appropriate. Moving down to item G, they're promoting heavy vehicle turning movements where the carriageway width is inadequate or barely adequate. And in this regard, I'm talking about the left turn from the southbound off-ramp. Now, in relation to that, the guardrail changes and off-ramp realignment measures that were described by Mr. Inder in his supplementary statement, they actually introduce new issues and don't resolve all of the existing ones. Yesterday, Mr. Inder also commented that truck drivers are professionals. However, crashes occur where truck drivers make mistakes. Professionalism does not mean mistakes won't be made. Going back to item H, there is some uncertainty regarding the applicability of the modelling results due to some of the uncertainty associated with trip generation rates. So if I can move from there, Mr. Mitchell, through into Appendix A, which is the summary table. And so this takes the table that was in my primary evidence and just provides additional material in relation to those. So I'm just proposing to go through a few of these points.
Thank you.
So if you can go to page 6, starting with issue 4.
Issue 4, inadequate spacing between Ohinewai interchange and Huntly Northern interchange. Am I looking at the right page?
It's exactly the right page.
Thank you.
So I'm just going to pick up on a couple of points here and then I'll move on to another item. So in the comments on Mr. Inder's rebuttal, so that's the large body of text in the right-hand column, while the effect may not be significant in the short term, consideration needs to be given to increasing traffic volumes on the expressway, growth in Huntly, and potential further growth in Ohinewai. The applicant has talked about having a left turn slip lane onto Ohinewai South Road, but that's only likely to be attractive for those road users that are needing to stop at the school. We can then go across the page. So I'm looking at issue 6. So this is under the heading interchange, and the issue is titled Site Distance from Southbound Off-Ramp is Inadequate. And just picking up down towards the end of the body of text there, the site distance to the left is inadequate, and the adequacy of the site distance to the right very dependent on operating speeds on Tahuna Road and on minimum criteria being adopted. And this comes back to my key point about the applicant talking about a number of compromises. Item 7, in relation to safety issues at the southbound off-ramp interchange. An increase of traffic on the southbound off-ramp will increase the existing safety risk at the intersection. I note that Mr. Inder proposes measures to address those safety effects, and one of those particular measures he refers to was related to an unapproved trial that was carried out, and the device referred to in that trial isn't provided for through the Traffic Control Devices Manual or through the Traffic Control Devices Rule. Therefore, it may not actually be a solution. I can then go to the next page, item 10 or issue 10. So this is the unacceptable road user movements associated with intersection 1. And just picking up halfway through that paragraph. So Mr. Inder places responsibility for crashes on unacceptable driving behaviour and bad driving. The simple fact, Mr. Mitchell, is that drivers make mistakes and crashes occur. Moving across to page 9 and issue 12 in relation to the lane configurations being too short. So this is in relation to the Tahuna-Lumsden intersection and the effect on the North Island Main Trunk Line overbridge. Now this is unlikely to be an issue unless there's a need for 2 westbound lanes exiting the roundabout, and that then becomes dependent on the actual trip generation for the proposal and other land use activities that will use the roundabout. There may be a need to increase the capacity of the roundabout, and if that does occur, my expectation is that the overbridge will need to be widened, but as Mr. Inder pointed out yesterday, the widening would actually require replacement of the overbridge. Now, sir, if I can just highlight a piece of my evidence that's in the wrong place, my statement that's in the wrong place. Under issue 13, the right-hand column, in there I'm talking about the Lumsden-Baloyi intersection. That comment should actually be in the box below under issue 14. The site distance requirements for intersection 3 still need to be protected, but the text that I've got there is in relation to Lumsden-Baloyi.
Okay, understood. Thank you.
So just in relation to that, Mr. Inder considers that the design of the Lumsden-Baloyi intersection can be addressed in future, and I agree with him, provided that no third-party land is required for the intersection. However, that doesn't presently appear to be the case. Then over the page onto page 10 and issue 15. So once again, looking at the Lumsden-Baloyi intersection and specifically the site distance constraints. So what the applicants demonstrated is that the land over which site distance needs to be protected is land that the applicant doesn't presently control. And if I can take you to page 12, and just another couple of points here. So item 23, the grade separated active mode facility doesn't accommodate all likely desire lines. And Mr. Inder considers that the addition of a 910 metre to a walking journey to the bus stop on the east side is not too far. However, I consider that the 910 metres will be a significant deterrent to those pedestrian journeys. And if you can just keep in mind that the average walk to work journey is 1.2 kilometres, and so the applicant's suggesting that 3/4 of that is used up just getting to the bus stop. In issue 24, there is the potential for pedestrians crossing the expressway between the Shand site and the applicant's site. Now this is sort of looking into the long-term future depending on what happens on the western side of the expressway, but I consider that it is important for potential future land uses to be taken into account just to make sure that this application for the rezoning doesn't result in the potential for unsafe pedestrian movements. So those are the key things I wanted to run you through, Mr. Mitchell. There were a few things that came up in relation to Ms. Loyne's presentation before lunch. I'm happy to provide feedback on those as well as necessary, but at this point I'm happy to take any questions you've got.
Thank you, Mr. Swears. Let's see if we have any questions for you. Mr. Mark?
None from me, thank you.
Mr. Fulton?
No, none from me. I see the more RMA issues. No, I'm fine, thank you.
Mr. Cooney.
Thanks for your evidence, Mr. Swears, and thanks for your table A. It's a good way of setting out issues clearly, rather than trawling through briefs of evidence trying to ascertain the issues. So thanks for that. The issues you raise are really nuts and bolts in terms of design and safety issues, aren't they?
Largely, yes.
Yeah, and many of those can be dealt with through appropriate mitigation, or if they can't, then it's our job then to assess the safety risk. Is that a fair way to put it?
I wouldn't encourage you to delve into the safety risk, because that's quite complex. But yes, they could. A lot of them could be addressed through mitigation. The point I'm trying to raise is that some of the items the applicant has identified as being potential solutions are potentially unworkable solutions. So just as a simple example, the roundabouts on Tahuna Road, they're proposing a roundabout that's smaller than it should be. Therefore, the mitigation should be a larger roundabout. Then the question is whether that can actually be provided if the applicant doesn't control the land that's needed to be able to construct that mitigation. And similarly for the Tahuna Lumsden roundabout, if they need to have 2 westbound exit lanes, then something needs to be done about the North Island Main Trunk overbridge. Mr. Rinder expressed yesterday that the applicant has concerns about doing that. So it's definitely a solution, but the applicant's already signalled that they have concerns about providing such a solution.
Yeah, I suppose a good example is the turn-in of the big trucks and going beyond the centre line. That's an issue where you both differ, for example, and it's up to us in that respect to look at the safety risk in that respect, isn't it?
It is to an extent, but something to take into account in that regard. So Mr. Inder's provided those diagrams and he showed the realigned guardrail for that left turn movement. The thing to keep in mind with the 2 guardrails, so he's compared the guardrail on the southern side of the overbridge with the guardrail on the northern side of the overbridge. The guardrail on the southern side of the overbridge is for westbound movements on Tahuna Road. So that's what we call a departure. So you're departing the hazard. So the design of that guardrail is going to be very significantly different to the design of the guardrail on the northern side of the overbridge, which is for an approach barrier. So if you were to move the barrier back to a similar point on the northern side as it is on the southern side, then you wouldn't actually be able to deflect a driver that hits that barrier away from the bridge abutment. So I've got some concerns about that. And the other thing to keep in mind is that if you allow for that splay, as Mr. Rinder suggested, then what it's going to do is to encourage road users approaching that stop limit line to have their vehicles positioned at quite an angle. So if you can imagine you're sitting there in your car and you're actually trying to look over your right-hand shoulder, potentially through the B pillar of your vehicle towards the limited westbound sight distance to the west. So that's assuming you stop. Otherwise, you've got the splay, which actually encourages you, rather than stopping, just to slip around the corner without giving way to eastbound traffic on the interchange. So I have some concerns about what Mr. Rinder presented.
All right. That's all I have, but I suppose in fairness, I did put to Ms. Lyons what the design capacity of the expressway is, and she said that you may know that, you may not. So,
I had a quick look at this over the lunch break. So recognise we're talking fairly broad figures. So based on the Austroads Guide to Traffic Management Part 2, and recognising it depends on a range of factors. So on a mid-block section, so away from interchanges, a mid-block section where you've got about 20% heavy vehicles, then 2 lanes would have a capacity of about 1,850 vehicles per lane. So about 3,700 vehicles for 2 lanes. And currently there's about 1,300 vehicles per hour on the 2 southbound lanes on the expressway.
Yeah. And do you know what if this proposal is granted, what the increase would be there?
Off the top of my head, no, I don't. But if we took a very conservative approach, so if you took the 1,300 vehicles per day, recognising that that's 2018 volumes, and there's no allowance for future growth in those numbers, and if we said that every household at the site generated one vehicle movement, and they all ended up contributing to that 1,300, then you would have about 2,400 vehicles per hour across those two lanes. But if I can just add to that, while that's still within the capacity before your level of service starts deteriorating significantly and you get significant adverse safety effects, I think it is important, as Ms. Loynes pointed out, to protect the expressway for its intended function, and that function isn't to provide for local trips that would be better assigned elsewhere.
Yeah, I think you've made that point pretty clear. Okay, thank you.
Thank you.
Just following on from that, Mr. Swears, the number of 1,300 currently, was that per lane or per two lanes?
That's per two lanes. What I've done there is I've looked at the 2018 traffic volumes, state highway traffic volumes, and I'm just looking at that now, sir. So
I was just trying to get you said 1850, give or take, per lane capacity, and I just wanted to check that the 1,300 wasn't a per lane figure, it was...
No, so that's two lanes.
Okay.
But just keep that, those are very rough figures.
All right, no, that's helpful, thank you. Just my final question, it's the only one I've really got to ask you. You essentially said, using the example of the roundabout that you think as currently proposed is too small, and to do it properly may involve, or properly in terms of what you'd be recommending, would need potentially to use private land. And you've said that that Amberley might not want to do that. But if traffic safety was a requirement of future resource consent applications and ITAs and all those sorts of things, wouldn't that be the time that those would be addressed? And if private land, for example, was required, and the plan provisions say you cannot undertake this activity until this interchange is upgraded, doesn't that put the onus on Amberley or whoever the developer is to solve that problem? And if they can't get access to private land and they can't satisfy the requirements of the ITA and can't convince commissioners that that's the appropriate solution, it would seem to me that they then just say, well, we've got zoning, but we can't use it. And have I missed something with that?
No, I think you're on the right track, sir. I mean, the concern I've got is that at this stage, the applicant's saying that for the rezoning, here's the solutions that we're considering, and there are some fundamental issues with those solutions. But you are right. At the resource management stage, it could be addressed through resource consent, and if they can't do it, they can't do it. And as you say, they can't use the rezoning. Okay,
no, I understand. I just wanted to clarify that with you. So thank you. Thank you, Mr. Swears. That's all the questions that I have. Thank you.
Thank you.
Ms. Sheard.
Yes, so that's the conclusion of our witnesses apart from Mr. Mayhew. So I'd suggest that we proceed with the Regional Council.
And as I said earlier, if there's something that arises out of Mr. Mayhew's evidence or anything else that you feel that you need to readdress us on, we'll give you that opportunity at the end of the Council's presentation to us.
Thank you. Mr.
Lanning, welcome.
Yes, good afternoon, sir. Can you see and hear me okay?
Yes, thank you, we can.
Yes, now I'm in a rather unusual position of the screen is and camera about 2 meters apart, so if
I understand.
Look at you,
I have the same problem. I've got screens with writing on them and screens with pictures on. I can't look at both of them simultaneously, so no problem at all.
Thank you, sir. Kia ora koutou. I understand that the opening legal submissions that were lodged last week have been read, and
yes,
whether or not I raise issues in those submissions, they will be taken into account by the commissioners when they make their decision.
Thank you. You, of course.
Now, before turning to the legal submissions, and I will go through reasonably significant portions of them because I think they do raise some important issues. I wanted to make some sort of brief sort of observations following the presentation from my friend Mr. Berry yesterday. The first is, in my submission, the general tone and some of the language used in the submissions is not appropriate and makes some allegations which in my submission are unfair and without any good faith basis. Describing parties in derogatory terms such as the old guard are not appropriate in my submission, and I adopt the submissions of my friend Ms. Shed in that regard. The fact that Amberley is not happy with the Regional Council's position is understood, but it is not, that does not justify my submission. That's the accusatory nature of Mr. Berry's submissions. And it is an unhelpful approach that has not, and I just record, will not be reciprocated by the Regional Council. Secondly, Mr. Berry included some lengthy quotes from newspaper articles in his submissions, which were read out yesterday. And I get the impression from, Sir, your comments at the beginning of yesterday that those newspaper articles will not be taken into account by the hearings panel. But I just note that the extent they're included in Mr. Berry's submissions, in my submission, that the same principle should apply. Now, Mr. Berry made a number of comments that appear to suggest that the regional councils have not approached this matter in a professional and objective manner. And if that is what Mr. Berry is suggesting, then they are strongly refuted. The witnesses, as for Waka Kotahi, have been careful to ensure that they meet their obligations as experts, and I can personally record, Sir, that I've made that very clear to them and they understand those obligations. They have carefully considered the proposed rezoning against the relevant planning documents and the law, and I'll come back to some of those issues in my legal submissions. And where appropriate, they have conceded matters, and they've actually reached agreement on things as well. So my submission, Sir, there is no basis to suggest that the council witnesses have not approached their business in a proper way. And in that regard, it's also relevant to note that the Section 42A team, which again comprise very well qualified and experienced practitioners, generally agree or have consistent views with the council witnesses. Now, a core theme of Mr. Berry's submissions is that the regional council has applied a doctrinaire, black letter, orthodox approach. This constitutes, in my submissions, either an intentional or unintentional misrepresentation of the regional council's case. The regional council's evidence has been focused on the requirement for the district plan to give effect to the regional policy statement and the national policy statement, and I'll come to that as well. And it goes without saying that those are legal requirements. So the regional council is not doing something unusual here. It's adopting the approach which in my submission it should take. And in that regard, it's interesting. I mean, and it's certainly well understood that the economic benefits of this proposal are significant. And that's very hard to deny given the investment that if this concept plan, structure plan is implemented, will produce. However, the law requires effect to be given to these documents. And I wasn't involved in the King Salmon case, but I assume that the marine farmers in King Salmon made similar arguments about the areas of the coastal space that they wanted to zone for marine farms, that it was going to create significant employment opportunities and economic opportunities. But the law requires these documents to be given effect to. The council witnesses have paid particular attention to the RPS provisions that allow for departures from the future-proof settlement pattern. This is what, again, the law requires, it's what the RPS requires. Disagreement of how those provisions are applied does not mean a witness or the council is throwing the book at Amberley. With respect to my submission, Mr. Berry has not engaged with the substance of what the council witnesses are saying, and personal attacks, and there are some of them in the submission, Sir, are not an adequate response in my submission. I was asked by Mr. Cooney yesterday as to the Regional Council's position with respect to whether it would accept an industrial zoning, and I wanted to address that. Unfortunately, we haven't had the opportunity to go back to the regional councillors and get a new position. And so, strictly speaking, the regional council's position is that set out in the further submission. However, as I said yesterday, sir, when you read the regional council's evidence, it's very clear in my submission that the substantive concerns relate to the residential component. And we haven't had the opportunity to assess what a rezoning of just industrial might look like. And so we can't say that the regional council would necessarily support such a rezoning, but I think as is the case for Waka Kotahi, that the concerns it's raising would, for the most part, not be there if it was just an industrial zoning. You might want to quiz me more on that later, but I think what's important is what the evidence is saying to you, Sarah, and what that is what you need to have regard to. That the motivations of particular parties is not actually relevant to your decision making in terms of the relevant RMA matters. So now I want to just move through parts of my opening legal submissions. And I wanted to start with paragraph 1.2, which is a summary of the Regional Council's concerns. And I just want to read this out because I think it is important context. Ohinewai is a small, relatively isolated settlement on the western side of State Highway 1. It is located at least 6 kilometres, and Sarah, I've got a footnote there because there's all sorts of numbers being thrown around about the distance from various settlements. It all depends on what you regard as Huntly, and it's about 6 kilometres for all intents and purposes, and approximately 12 kilometres south of Te Kaupata. Its primary access is via State Highway 1 with very limited public transport servicing. In addition, it has very limited servicing in terms of water and wastewater services. It is not surprising, therefore, that the future-proof growth strategy and the regional policy statement do not identify Ohinewai as an area for urban growth. Rather, they, consistent with good urban planning or good planning practice, promote urban growth occurring within or adjacent to existing urban areas. And B, in the Regional Council's submission, the proposed rezoning will not give effect to and is contrary to the regional policy statement. And I'm not going to read through the subparagraphs under that because I'm going to come to those points later. But Sir, I did want to highlight subparagraph C, which is on page 4 of the submissions. The proposed rezoning results from a decision by Ambury to choose a site at Ohinewai, based on, in my submission, a limited assessment of options that considered criteria determined by Ambury to suit its commercial objectives. And that is not meant to be a criticism at all. That's sensible commercial decision making. The criteria, however, did not take into account any broad strategic planning issues, nor allow for options that might, for example, have placed the residential component separate from the residential component.
Mr. Lanning, could I just discuss that aspect with you?
Sure.
We've heard evidence that they looked at Huntly, and one of my questions was, well, did you look at the urban boundaries there? They said, yeah, we did, but it's full of mine shafts and unsuitable land. Mr. Turner then said, we looked around within an hour's drive of Auckland to other areas, but we couldn't find anything. And this was the most appropriate place. So they have looked at other alternatives, haven't they?
Well, Sir, in my submission, that might be the case, and but if I had the chance to ask questions, which I obviously don't, in this proceeding, I would have asked questions like how many sites were looked at, where were they, what assessments were undertaken on each site, What were the reasons for each site not being proceeded with? And in my submission, there are statements saying that sites were looked at, but that is all. And in my submission, that does not amount to even something close to an adequate evidence of what was actually looked at, so that you can be satisfied that it wasn't just, for instance, price that was the reason. And again, I'm not there might be justified reasons for discounting particular sites, but there is no evidence. Like I say, how many sites, where were they, what assessments, and why were they dismissed?
Okay.
I want to move on just briefly in terms of the evidence, just so that you know, commissioners of the order. I want to try and get the easy stuff out of the way first, without wanting to make dangerous assumptions, and have Dr. Wilding, and then Mr. Bashir, and then Mr. Kuo, then Dr. Hackle, Mr. Keenan, and then Ian Mayhew in that order. So it's slightly different order. So
just whatever suits you is fine with us, obviously. Yeah, who was that?
Oh,
I'm glad I'm on Zoom.
I was going to say that sounds like a COVID sneeze.
So, Commissioners, I now want to take you to section 3 of the, not yet, section 3 of my submissions, which deals with statutory context, and you'll be more than familiar with the statutory context. But it is a critical part of the Regional Council's case. And in particular, I've set out there what you've probably read many times, the Supreme Court's statement on the need to have to give effect to these higher planning documents higher up in the statutory hierarchy. And the Court of Appeal, Supreme Court, again reminding us that's a strong directive, strong direction. And the reason for that is a statutory assumption, I guess, that the regional policy statement has passed through the RMA process and is deemed to give effect to Part 2 matters. And I'm going to come back to these arguments around what scope there is to look beyond the RPS 2 Part 2 of the Act. I will come back to that. So at subparagraph B on the top of page 6, I say there, more specifically, you have to be satisfied that this proposed rezoning at Ohinewai implements the regional policy statement. And in particular, the provisions of the regional policy statement addressing urban growth. And in our submission, by enabling an isolated car-dependent urban settlement at Ohinewai with few community services, it'll have some, but it will have few, the proposed rezoning would be contrary to the regional policy statement, and therefore in our submission unlawful, again, because this is a strict legal test that must be met. And as I said earlier, I will address the issues around whether the regional policy statement should be given less weight or should be, I guess, opened up to some considerations outside the regional policy statement.
Mr. Lenning, just on that issue, the planners all agreed that we could look at the alternative land releases provisions in the RPS. So it's not simply a case of this hasn't been identified, therefore it's contrary. The RPS specifically allows us to consider this as an alternative land release. So do you want to just comment on that?
Well, I will come back to that because that is addressed in my legal submissions, but absolutely, sir, yes. Our position is the starting point is the map showing the settlement pattern, but where someone wants to do something different or a different place or a different order, then the RPS expressly provides a mechanism for doing that. And so that's why in my submission, what your decision ultimately is probably going to come down to is looking very closely at those principles and as to whether those principles, whether we're consistent with those principles, but also the new NPS as well. And the key issue there is whether what will be achieved here is a well-functioning urban environment. So in my submission, that those probably all of these arguments boil down to those provisions.
Are you going to come back to this issue later, are you?
Yes, I am, sir.
Yeah, okay.
I'll deal with that. Next one I just wanted to point to is subparagraph D at the bottom of page 6, so the other strategies and plans. And I'm not going to spend much time on that. We do have concerns about the Waikato 2070 document, and I can answer questions on that if you like, but I don't propose to spend much time on that. But the other documents which in my submission are also matters or documents which should be had regard to are the documents produced under the Land Transport Management Act in relation to the management both of the transport generally and public transport. They are statutory documents required to be produced, and so they are in my submission things that you must have regard to as well. I just briefly wanted to move through the reason why the Regional Council's here, because again, there seems to be some criticism of that. And so paragraph 3.2, I'm not going to read through this. But paragraph 3.2, I'm there the relevant or most relevant section 30 functions of the Regional Council in relation to integrated management, providing for development capacity, and the integration of infrastructure with land use. So that they are obviously very, very important functions of the Regional Council, which the RPS has a key role in delivering on, and I've recorded that. It's a paragraph B. I think C, which mentions section 84 of the RMA is important. That creates a duty on the Regional Council to enforce observance of the regional policy statement. So again, that's another reason why the Regional Council is here. The Regional Council has a important, if not critical, part to play in land transport management, and I've just mentioned those previously, and I've mentioned those at subparagraph D as well in terms of those two key plans, the Regional Land Transport Plan and the Regional Public Transport Plan. And I think what I did want to highlight there too is the statutes which create the requirement to produce those documents has a link back to the Resource Management Act and an obligation that when those documents are being produced to have regard to things like the regional policy statement and district plans. So there's a linkage between the Land Transport Management Act and the RMA, which I think is relevant here. So I can move through now to the issue over the regional policy statement and whether there is scope to look at or consider Part 2 matters, or there also seems to be an argument that for this current matter, the regional policy statement should be deserving of less weight, or something. I'm not quite sure how it's being, how it would be argued, but I just wanted to address that matter. So I want to begin at paragraph 4.6. The Regional Council strongly rejects any assertion that the regional policy statement does not meet all of the requirements of the RMA, including achieving the purpose of the RMA. But more specifically in relation to the issues raised by the proposed rezoning at Ohinewai, the regional policy statement clearly covers the field in my submission. I noted earlier in my submission a case from Her Honour Judge Harlan's, the A.A. King case, where she highlighted the value in the future-proof document and the strategic direction set out in the regional policy statement. So as in that case, the regional policy statement is, in my submission, directly on point in terms of the core urban growth issues to be considered by the panel. The relevant regional policy statement provisions are addressed in Mr. Mayhew's evidence. Importantly, these provisions directly address the location, nature and scale of urban development in the region. Mr. Cooney, this might be where I hopefully will answer your question or respond to your point. First, the starting point is that within the future-proof area, which includes Ohinewai, new urban development shall occur within the urban limits indicated on map 6.2, which Ohinewai is not. And I would accept the chair's comment that the plan itself is indicative, so that needs to be sort of borne in mind when you're determining whether you're giving effect to that particular requirement. So that's the starting point. Secondly, the regional policy statement allows for the potential of alternative industrial and residential land release patterns promoted through district plan and structural plan processes, which this rezoning request is. However, the regional policy statement requires such a proposal to be justified in terms of consistency with the principles of the future-proof land use pattern, excuse me, and the effects of the change must be consistent with the principles set out in section 6A of the regional policy statement. I don't think there's much argument about what consistent means, but my pocket Oxford Dictionary described it as, or defined it as being compatible or in harmony with. The future-proof and section 6A principles comprehensively address issues raised by urban development generally and outside the urban limits shown on map 6.2 specifically. It is notable in my submission these principles demonstrate a strong preference for locating new urban developments within or adjacent to existing urban areas. I just want to pause there, Commissioners, because behind these policy directions to try and establish new urban development within or adjacent to existing urban, underlying that policy approach are some very, very good outcomes that we're trying to achieve in terms of public transport, infrastructure provision, giving people access to more services, that sort of thing. So that it's not just a policy that is designed just to be a policy. There are actually important underlying outcomes which we're trying to achieve through these policy statements. Now, in his evidence in chief, Mr. Oliver expresses an opinion that there are two aspects of the RPS that he considers are categorised as incomplete coverage and therefore justify some recourse to Part 2. The first one is the fact that the regional policy statement has not been updated in response to the old NPS. And secondly, that the settlement pattern in the regional policy statement is somewhat dated. So in response to those 2 points, my submission, the fact that the regional policy statement may not have been fully updated in light of the past or the previous NPC does not translate to a regional policy statement not covering the field in terms of addressing Part 2 matters. That NPS has obviously been replaced now, but in any event, you will need to consider and ensure that this rezoning, if you wish to approve it, gives effect to the new NPS. And I'll come to the new NPS in a minute. So in my submission, that doesn't mean that it opens it up to Part 2, because you are to give effect to both the RPS and the NPS. To the extent there's anything missing between the RPS and the NPS, then that's covered by the fact that you have to give effect to the new NPS. So that doesn't mean that you can bring in Part 2 matters, because the new NPS should be giving effect to Part 2 of the Act. And secondly, to some extent, any settlement pattern that's going to be set out in a planning document is going to be dated because the world moves on. But importantly, in this case, the RPS does allow for this flexibility and this these sort of deviations, for want of a better term, from that specified settlement pattern. And that's, like I said at the start, that in my submission is probably going to be the core of your consideration of this matter. So I can now move on to section 5.
Just before you do, Mr. Lanning, do you accept the 6A principles are not absolute?
I would prefer, I'm not sure if it depends on what you mean by absolute, sir.
Well, are they directive or discretionary?
Well, the direction, I suppose that the direction is to, one, have regards to them, and secondly, to test the proposal as to whether the proposal is consistent or not with those principles. Now, I think I accept that, well, I do accept that some of the principles will be more relevant and some of them will be not relevant at all for particular proposals. And that's ultimately a planning judgment as to the extent of relevance and then the extent of compatibility or not. Does that answer your question, sir?
Well, yeah, it does. I suppose really what I'm saying is it's not a checklist you have to tick off every one. You've just got to weigh them up and see how they apply. Would you agree with that?
Yes. In my submission, sir, it is I do have the principles in front of me, but they ultimately require, like I say, a planning judgment about, one, their relevance, and two, whether whether a particular proposal is compatible with them or not.
Okay, just moving off that point to the next point about the policy statement covers the field. It was promulgated in 2009. You've got a future-proof study in 2017, which says things have got to be more responsive. And you've then got the NPS policy 8, which says you've got to approach things in a responsive way. Couldn't the argument be that the RPS therefore is lagging behind all of that, and it doesn't cover the field in the way, both from the NPS point of view and also the new studies that have been done, including WICO 2070. So it doesn't cover the field, and therefore we can revert to part 2 if we have to.
So the way I'm looking at this, and bearing in mind this is all very new in terms of the interaction between these documents, but the way I look at this is that the RPS, as we've just been discussing, has express provisions allowing for flexibility, allowing for responsiveness, however you want to describe it. Those principles, as I understand, as between the planners, are fairly non-controversial. They reflect fairly orthodox planning outcomes that should be sought. I understand that there was an update to Future-Proof to 3 years ago, and the outcome of that was the Future-Proof principles were effectively fit for purpose. Mr. Mayhew discusses that in his evidence. This issue over the NPS and its policy 8, or I think it is, that I guess encourages or facilitates responsiveness, nimbleness in the planning regime. I think there's an argument to say that the RPS already does that, as I say, through these provisions that are expressly, that they're there, providing for this specific set of circumstances. To the extent the NPS goes further than that and says that we should actually be even more responsive or nimble, what is critical in that policy is that it's still, the outcome still has to be a well-functioning urban environment, and that is a core part of the regional council's concerns here, that this is not meeting those minimum requirements, and that's how they're described, for a well-functioning urban environment. So the NPS is not saying just build everywhere you possibly can. It's still saying we want good quality outcomes. Yes, be flexible, but we still want good quality outcomes. So that's the way I'm reading those two documents together, sir.
So it really comes down to an evidentiary planning issue on whether this proposal complies with the 6A principles, does it? That's it in a nutshell, isn't it?
Well, and now you have a requirement to ensure that the NPS requirement that it's a well-functioning urban area is achieved as well. So there's two things. You have to give effect to the, as you know, the NPS as well. So it's both those principles in terms of, is it consistent with those principles and the RPS? But secondly, you have to be comfortable, or you have to be satisfied that this proposed rezoning will give effect to the new NPS as well. And all I'm saying is, between those two, it's hard for me to see any scope for a part 2 consideration, because they are, those two documents are dealing with all the issues which are on the table.
All right. Okay.
Okay. So now, Commissioners, I wanted to move to part 5 of my legal submissions on page 12 and deal with this issue of integrated land use and infrastructure planning. In paragraph 5.1, the Regional Council is concerned that the proposed rezoning is the antithesis of integrated land use and infrastructure planning. The need for such integration is recognised in section 31GB of the RMA. It's a statutory function. Future-proof the regional policy statement, the proposed district plan, and as well as a well-accepted core principle of resource management. And it's also reflected in the case law, and Mr. Berry mentioned these cases in his legal submissions. I've set out a quote from the North Shore Bulk case, which referred to the Four World case. And the upshot was the court saying it is bad resource management practice, and contrary to the purpose of the Act, to zone land for an activity when the infrastructure necessary to allow that activity to occur without adverse effects on the environment does not exist, and there is no commitment to provide it. And I expect there to be some questions on that second part of that quote, which I will address as we go through this, but I'm happy to respond to any questions on that particular point of law now, if you like. Move on.
No, I think carry on, Mr. Lemmy. Thanks.
Thank you. So I want to move now to paragraph 5.3. So the key issues in the Regional Council's point of view in this regard is one, the lack of a cost-effective public transport service to and from the development, and secondly, the uncertainties as to whether the development can be adequately serviced with water and wastewater. So in terms of the public transport matters, I mean, the key issue here is that this is Ohinewai is currently a very small settlement, 159 people. It's serviced by some bus services which run in the peak times, a couple of bus services per day, and one off-peak between Hamilton and Pukekohe. So very limited, and that's probably it's probably sort of putting it at too high level public transport services. What is proposed here is a new settlement, significantly larger, 3,100 residents, 2,400 employees approximately. The only access, practical access, is going to be Long State Highway 1 in a car. And yes, there might be cycling connections to Huntly and beyond maybe, but I think everybody needs to accept that, based on the evidence, that it'll only be a few people who that will be feasible for. And I've pointed to Dr. Fairgray's evidence talking about the need for people to access services to go well beyond Huntly as well. So I think that is important. 5.6. I think what's really important here is to understand that public transport servicing and planning and contracting and funding is subject to statutory processes. It's conducted by the Regional Council, but important decisions are made by the Regional Land Transport Committee. At paragraph 5.7 there, I note that Mr. Kuo's evidence is that it's not cost effective to provide increased public transport services to the proposed development area. And put simply, that is because what is proposed is an isolated urban area that is disconnected from existing urban areas, combined with a relatively low likelihood of demand. Mr. Kuo's opinions are entirely consistent with well understood and accepted principles of good urban planning that facilitates the provision and use of public transport. And those principles are reflected in the new National Policy Statement, the RPS and the Land Transport Management Act. Paragraph 5.8, I just note some of those Section 6A principles that relate to this public transport issue, and some comments that was made by Mr. Inder in his evidence. Mr. Inder states that the master plan integration of the proposed land use activities absolutely enables and promotes the minimisation of private car use. However, in my submission, that ignores the fact that even if the development is implemented in accordance with the structure plan, there is no guarantee that the houses will be acquired or occupied by Ohinewai workers. Even if the houses are occupied by Ohinewai workers, there will be no other members of the household. There will be other members of the households who will not work at Ohinewai. And for all of those residents, they will need to access a range of services outside of the site. And so what's important there to me is, and following some of the discussion with the witnesses, the Waka Kotahi witnesses earlier, is that there's a real focus on those people who are going to be going from home to work and back again. And what is proposed here are 2 and 3 bedroom houses. There will be other people living there. And I think that is important to think about their needs in terms of access to services and opportunities outside of the site. So therefore, the location and nature of the proposed development will not minimise the need for private vehicle use, which is principle 2. It will do the opposite in my submission. Similarly, the proposed development will not maximise opportunities for people to live, work and play within their local area. Importantly, these principles address more than environmental impacts of private vehicle use, as they reflect the multiple social and economic benefits of giving people options to access a range of activities and services. Now, it's correct that public transport can in the future be serviced by public transport. It is difficult, in fact, to think of anywhere where that would not be possible. However, Mr. Inder ignores the reference to this being done efficiently as required by principle 3. And creating yet another community separate from existing urban areas does not facilitate the efficient provision of public transport services. And before I leave public transport issues, so I just note in response to questions from the panel, and I think Commissioner Fulton in particular, to the applicant's transport witness yesterday, it was along the lines of a statement was put in terms of the regional council would have to provide a service if there was a demand for it. Now, that is not correct. There is no statutory obligation to provide public transport services. It's a discretionary function of the regional council. But I guess that the witness's answer was revealing of the regional council's concerns, and he said that yes, they have to provide a service to meet demand, even if it is not efficient. And that's not a quote, so I might have got that slightly wrong, but that was the essence of the answer. And that is what the regional council is trying to avoid here, creating these situations where there is demand to provide a public transport service, but it's inefficient.
Mr. Lennon, you're up to what, water and wastewater servicing now, aren't you?
Yes, sir.
Before you get off this issue, you were very critical of the applicant, saying that the regional council's taken a black letter approach. But when you boil it all down, because someone can't catch the bus to Huntly and they have to get in their cars, that is the basis on which the regional council is saying this should be turned down. As simple as that?
Well, the public transport issue is one of the issues which are being raised, yes.
Okay,
It's not the sole reason.
right.
But Sarah, I guess I would, again, this is not, yes, people can have cars and they can drive to places. That's what most people do. The point here is, though, that these will be households with people with different needs, different times of the day. They'll be wanting to access different things. There'll be teenagers wanting to access tertiary education, for instance. The point is that we want to create communities where people have as much choice to access opportunities and the things they need as much as possible. And creating urban communities that are solely reliant on private vehicles is not just a sort of a, I don't know, like I say, it's not just the impact of the vehicle use on the environment. There are some social impacts of having households reliant on private vehicle use. And not being able to jump on a bus, ride a bike, walk to things, to give those people opportunities is what we're trying to achieve through the regional policy statement. And in my submission, that's what the national policy statement is trying to achieve through its definition of well-functioning urban environments. So I'll move on to the wastewater or water and wastewater servicing. So there's heavy reliance on this new servicing strategy. It was produced very recently during this year. I'm not going to go through the details of that. And it's well covered in Mr. Mayhew's evidence in terms of where that's left us in terms of how much certainty or uncertainty there is. And certainly his views are shared by Mr. Donald on behalf of Waikato Tainui and the Section 42A experts as well. But I just wanted to touch on at paragraph 5.13, the Memorandum of Understanding that has now been produced, again, very recently. And this comes back to that statement in that Four World case where it talked about a lack of commitment to provide infrastructure. So at paragraph 5.13, I say Mr. Gazer's rebuttal evidence attaches a Memorandum of Understanding signed by, that should be the District Council, not Discharge Council. Punish my junior, and Ambury. Presumably this is to provide some comfort that the water and wastewater and other infrastructure issues will be addressed. In my respectful submission, the MOU can provide very little comfort because firstly, it is non-binding insofar as it does not give rise to legally enforceable obligations. And secondly, the strategy itself and the servicing solutions it recommends have not been adopted by the Waters Governance Board or the District Council, and have therefore not been reflected in the District Council's long-term plan. And the LTP will be subject to the LGA decision-making process, which includes public consultation. And again, there are statutory processes to be gone through that will have public input, and they have not even started. Paragraph 5.15, public input. Paragraph 5.15, I just note there the various, the strategy itself is a good bit of work for as far as it goes, but it is even internally it's saying there are some significant bits of work which need to be done to confirm that these recommendations or these servicing options are actually feasible. And that includes impacts on Māori cultural values and no public consultation and no assessment of consenting or affordability. So they're fairly important, critical aspects of the strategy which have not even been undertaken at this stage. So Sarah, unless there's more questions on that particular issue, I can move on to the social effects matter.
Those same issues in relation to water and wastewater arise irrespective of where in the district this proposal was located? I mean, even if it fitted future-proof, for example, perfectly, it was on all fours with it in every respect, it still raises the issue, doesn't it, in terms of how would future wastewater, using that as a for instance, be addressed? So you're not suggesting that that aspect is particular to Ohinewai, are you, or are you?
Well, I don't know the sort of technical ins and outs of whether it would make any difference where development would go in terms of the overall option. At the
moment, the proposal is to say take it to Huntly. Sorry, Mr. Mang, I didn't mean to interrupt.
Sorry, so you're suggesting, or you're putting to me, if this development was in the urban environment of Huntly, then the same issues would be faced.
In relation to wastewater, because that's where the wastewater is expected to go. So I would assume, other than the connecting pipeline, if there's issues around the ability of the treatment plant to process the water, the treatment plant doesn't actually know where it's come from. It just knows that it's arrived.
Yeah, no, conceptually, I'd have to agree with that, sir. It would have to be obvious. Technical folk might have some reasons for there being a difference, but that would certainly make sense to me.
Okay, thank you.
Moving on now to social effects, which is obviously a point of contention still. And again, it was interesting to note that Mr. Quigley this morning noting that there was a lot of agreement as between the experts. So again, going back to my point right at the beginning about the regional council experts sort of having a doctrinaire approach or whatever. Again, there's a difference of opinion, but the Ambury witness acknowledging that there was a high level of agreement as between the witnesses. So again, I'm going to skirt through this part of my legal submissions, but what I did want to focus on, because I don't think it was addressed very well by Mr. Quigley this morning, and that's dealt with at paragraph 6.2. And this is this issue over whether a social impact assessment should look at various options or just the master plan, as Mr. Quigley has done. And obviously, Dr. Hackle, in her evidence, explains why, in her view, it is important to look at other options. And listening to the discussion this morning, it seemed to me that, whether it's people talking past each other or whatever, but the issue is not so much the assessment looking at separate, discrete options or alternative outcomes. In my submission, it is still important for the panel, for the hearing panel, to understand what the potential effects are of realistic applications of the proposed rezoning. So not the master plan. The master plan is not mentioned in the proposed rezoning. But in my submission, the panel still needs to understand what the potential adverse effects are of partial implementation of the structure plan, because as was mentioned this morning, it's a discretionary activity to do something different. So who knows what in 10 years' time, if this rezoning is allowed, who knows what in 10 years' time, what the new owner or new owners might decide to do with the land. Now, in this case, the council's evidence is that partial implementation of this structure plan will have a different set of social effects. So it's not so much looking at a different option of 20% industrial and 10% residential or whatever, that sort of thing. I accept that that would be arbitrary, but I still, in my submission, would say that it's important for a social impact assessment to look at what people might be concerned with if only the industrial is undertaken, or if the master plan didn't turn out the way it would look like. And it might be questions to people such as, what are the really important parts of this proposal? Is it the employment? Is it the residential? And so in my submission, there is still a lack of evidence from Amberley as to what those potential effects are, and that's not necessarily to say that they would be of the nature that you would decline the rezoning, but you need to be confident that the proposed objectives, policies and rules will adequately respond to those potential adverse effects. Because the point here, sir, is important. These social effects are not going to be the responsibility of this developer in 10, 15, 20 years' time. They'll be the responsibility of the community and the public agencies to support them. So in my submission, it's important to get this right. Unless there's questions on that anymore, I don't want to say any more on that particular issue.
No, I think we understand the point that you're making. Thank you.
I mean, I've made some comments there about the lack of input from current Sleepyhead employees. I'm not going to say any more than I've said at paragraph 6.4, that given the underlying the vision that Sleepyhead has for this site in terms of providing for its employees, it does seem curious that there's no evidence from those employees as to whether this is something which they would actually want to engage with, or if they were, what sort of things they would want to see in this community, how they would want to see it working. I won't say any more on that point. I can now move on to the National Policy Statement on Urban Development. And I've probably dealt with most of this now, so I'll just cast my eyes through it. Yes, I think, I mean, we could argue for a long time about what an urban environment is and whether the proposed policy, NPS objectives and policies apply to this particular proposal. We've approached this on the basis of saying, well, it's probably not a very useful argument or discussion to have. Let's just imagine we have to apply the NPS. The core part of this NPS, no matter which provision you look at, is that the outcome must be a well-functioning urban environment. That is defined very clearly in Policy 1, and it's defined in terms of minimum requirements. So things that must be achieved. And that's set out on page 22 of my submissions. We say that the proposed rezoning will not achieve minimum requirement C or minimum requirement E. And I think I've probably gone through the reasons why that is the case. And so unless there's questions on that, I don't wish to spend any more time on it. No questions? So now I can
carry on, please, Mr. Lanning.
So we're almost there, sir, which you'll be thankful for. Now I want to move to section 10 of my submissions on page 26. The section 42A staff report. I acknowledge my friend's retraction of one of the comments in his legal submissions, but I do want to acknowledge that the section 42A report, including the recent update that we got last week, has been carefully prepared in my submission, and I think, don't think there's any debate that they have been prepared by an experienced planning consultant and a team of very experienced specialists. And also note there that they generally concur with the concerns, at least on a general level, that are shared by the Regional Council witnesses. So in terms of a conclusion, I do want to read through this. The Regional Council is under a duty to enforce observance of the Regional Policy Statement, which in this case reflects the regional strategic consensus reflected in future-proof strategy. The District Plan must give effect to the RPS. A proposal to establish a new discrete community physically separated from existing urban areas that will be car dependent for the vast majority of trips and reliant on infrastructure and services that are speculative at best, is the antithesis of what the RPS requires. As such, the proposed rezoning will not implement or give effect to the RPS. And for the same reasons, it will not be enabling a well-functioning urban area as required by the NPS UD. The Regional Council accepts that the industrial component would generate employment and the consequential social and economic benefits. However, apart from the initial construction of houses, the residential component will not. Amberley has not explained why the residential component is necessary, apart from it being part of its vision. And moreover, the options of providing the housing within the existing Te Kauwhata or Huntly townships has not been explored, or at least there's no evidence of what was explored. Perhaps that's more fairer, sorry. Such options would avoid the potential social, transportation and flood hazard related issues raised by the Regional Council. However, without prejudice to those submissions, should the panel reach a different conclusion, it is respectfully suggested that the most appropriate way forward would be, and I think there's consensus now amongst the parties, to issue some sort of interim decision or interim guidance or note, don't mind what you call it, to allow the parties further time and the opportunity to develop proper and adequate district plan provisions. So on that note, sir, I can end and answer any further questions.
Thank you, Mr. Lanning. Mr. Fulton, do you have any questions?
No, not at this stage. No, I'll ask more technical ones later. Thank you.
Thanks, Mr. Fulton. Mr. Marg?
Not from me, thank you.
Mr. Kearney?
No, I've asked all mine, except there's just one, Mr. Lanning. You say 11.2, which you've read out. Amberley has not explained why the residential component is necessary, apart from it being part of its vision. That's not the evidence that Mr. Turner and others have given us. They've actually said it's to provide affordable housing to the company's employees, and also I would anticipate it promotes the work, live, play concept that's deeply embedded in the future-proof stuff. Do you want to comment on that?
That statement there, sir, is to, I guess, and maybe I was a bit shorthand with it, is really saying that there's no evidence to explain or to say that just an industrial zoning would not still be meeting Sleepyhead's or what Sleepyhead needs. Effectively, what I'm saying. So not necessary in terms of necessary to establish an industrial activity at that site. So I get, okay. So yeah, and part of that again comes back to this point that there's no evidence to say that, or what was considered in terms of some redevelopment in Huntly, in terms of residential development and providing some housing in Huntly. So it's necessary at the site, if you like.
That's all, Mr. Kearney, is it?
Yeah.
Just one question from me. Thanks, Mr. Lanning. And it's a question I asked of Mr. Oliver. And I imply no criticism in the question. The district council has appointed independent assessors, if you will, to assess the proposal on the basis that as the proponent of the plan, it needs to be careful, you know, which hat it wears when making different points. And we're aware of the political representatives' different view from those independent assessors. I can't ask this question of a council witness, at least I don't believe I can, because the only council witnesses that are here are technical ones. So I'm putting this question to you. Is the council as a statutory entity expressed any view on if the relief sought in the council's submission was adopted and the economic benefits of this proposal were lost to the region as a whole? Have they given consideration to that point? And if so, could you just advise as to how that has occurred? Sorry, that's a little bit of a clumsy question. I was trying to be careful how I express myself.
I appreciate that, sir. I have not been privy to council decision making in relation to the further submission and this issue, but I can try and find out and provide you with an answer to that separately if that's.
I think we just want, because it's one thing, and I don't mean this, as I say, casting no aspersions whatsoever, but it's one thing for independent experts to say this is our professional view. It's another thing for the entity as a whole to confirm that that represents the organisation's view as a whole, given the implications of what a decline decision, I'll call it a decline decision, might mean. And we'd just like to be to have some clarification of that, please.
Certainly, sir. And I'll just say, just in relation to that, I mean, I'm not going to say it's a problem, but the issue we've had is that this rezoning proposal has been put forward as a single proposal. All parties have been required to respond to that single proposal, including the Regional Council, and assess it on that basis. It's only through the expert conferencing and producing evidence and analysing what's proposed that it's become very clear that the concerns are with the residential component. As I said in my legal submissions, the council accepts the employment and related benefits that certainly the industrial component will generate. And I'm still a little unclear as to what Amberley's position is on this, because on the one hand, Mr. Berry says in his submissions that they would welcome a decision of just industrial zoning, but then very clearly in further in his submissions and in the evidence, there's still a very clear desire by Amberley to pursue the master plan concept. So I'm a little unclear still as to what Amberley's position is on this. And as I said at the beginning, we haven't been given an option of just an industrial rezoning to assess. So yeah, but I'll see what my instructions are, sir, and respond in the way I'm instructed to.
No, that's fine. That would be helpful. Thank you. Thank you for those submissions, Mr. Lanning. They're very helpful.
Okay, so first witness will be Dr. Wilding. So hopefully you're going to be able to see him.
Good afternoon, Dr. Wilding. Welcome.
Thank you very much. Do you mind if I share some maps with you on the screen as we go through?
No, that would be fine. I think Mr. Baloyi will just need to...
He should be able to share his screen now.
Okay. Might be a moment. I'll mostly be, these are maps from my summary statement, so
no, but it's helpful for them to be on the screen, so thank you for that.
Okay. Can you see my summary of evidence?
Yes, we can.
Great, thank you.
I've got it on my own screen and I can see it a little bit clearer because it's bigger, but that's okay.
Sure, yeah. No, it'll mainly just be for those maps, so you know what I'm talking about. Yeah, so I'm Thomas Wilding, Team Leader of Freshwater Science with Waikato Regional Council. And so skipping straight through, excuse me, go. Okay, so an important point, black mudfish have not been found within the proposed rezoning site from the surveys that have been undertaken to date. However, the possibility of occurrence remains with black mudfish recorded close to the proposed rezoning area. Now, the national distribution, this is, you could say this is the worldwide distribution. The national distribution of black mudfish confined to the North Islands, and it's limited, and the proposed rezoning site is located among a large cluster of records. Can you see my mouse?
Yes.
Okay, so the yellow is to highlight about where the proposed rezoning site is, in amongst these dots, which are the recorded black mudfish locations. And that's adjacent to the Whangamarino wetland. So there's a bit of a cluster there. The second map, this shows the property where rezoning's been considered, and the red dots are the where black mudfish have been recorded. Okay, so a few over here and a few over here, and these are the same dots that were on the previous map. So just zooming in. So they're nearby, and they're being found in habitats like those that we see on the property. You know, those farm drains. So if black mudfish are present, then those waterways would qualify as significant habitat of indigenous fauna, which in accordance with criteria 11A of the Waikato Regional Policy Statement. And this is because the black mudfish are classified at risk declining in the Department of Conservation Freshwater Fish Threat Classification List. Few attempted translocations of mudfish, this is when you try and pick them up and move them to somewhere else, to a new home. Few attempted translocations of mudfish have succeeded in establishing self-sustaining populations and new habitats. Given translocation of mudfish populations is unlikely to succeed, the two options are to avoid loss of habitat effects through habitat protection for this at-risk species, or to accept the risk of failure of that translocation if mudfish are encountered at the site during development. If the development proceeds, the fish management plan proposed in the draft provisions should include provisions for long-term monitoring so that habitat offsets can be triggered if a translocation fails. Changes to the wording of a provision for earthworks would be required if the fish management plan is intended to apply to habitat for black mudfish, which can include artificial drains and wetland areas. Just keep up with this on here so as not to confuse anyone. All right. So in response to the rebuttal evidence, so I've read the evidence of John Oliver and Chad Croft. And John Oliver states that the Ecological Rehabilitation and Management Plan has been amended to better accommodate the risk that black mudfish may be found in the future. And I've reviewed provision 16.6.3. The reference to watercourses as a trigger for that management plan has been removed, so I support that change. There is explicit reference to a monitoring program to assess success of any mitigation measures, including any translocations. And again, I support this amendment. There does not appear to be any requirement to protect habitat of Indigenous fauna if feasible to do so. And as I indicated in paragraph 9.7 of my evidence, in my opinion, the starting point for a management plan should be avoidance and protection of the habitat. And this component does not appear to be incorporated into the provision. No response to Chad Croft's rebuttal, which is focused more on the terrestrial pest control, where I don't have expertise. Section 42A, the report rebuttal evidence. Having read section 4.4, ecological of section 42A, Ms. Trenoth has made a reasonable interpretation of the ecological evidence, in my opinion. So that's the end there. If you've got any questions, I'd be happy to help.
Thanks, Dr. Wilder. Let's just see if there are any questions. Maybe if you could turn your screen off now so that we can see you rather than the screen, please. Thank you. Mr. Fulton, do you have any questions?
No, I don't have any questions. Thank you.
Mr. Mark?
No, thank you.
Mr. Cooney?
No, thanks.
No, and I don't have any questions either. Thanks, Dr. Wilding. That's all pretty clear to us. Thank you.
Thank you.
I think we might have one more witness, Mr. Lanning, then we might break for afternoon tea. That's
certainly, sir.
With you.
Yep, no, that's in your hands, sir. So the next witness is Mr. Bashir on the flooding issues.
Thank you.
Thank you, Mr. Chairman and members of the committee. Probably I don't need to introduce myself here. In my summary, there are 3-4 areas that I have responded to. I'm assuming that you have already probably read the summary. So there was the APL, there is the submission of Dr. Webby for Mercury, the Shands property submission, and then the section 42A report. And so in terms of the APL, we have essentially agreed on the, after review of the evidence and the modeling, that the stop bank breach scenario, essentially the model has shown that it does not go through the property. It actually just misses the property to the north. And so in that regard, there is no need to have a provision for an emergency management plan in the district plan of the zoning, rezoning is approved. The other element was setting a level at which buildings can be built. And so the whole area is more affected by the Waikari level. Waikari level, 100-year, including climate change, in our opinion, is that RL8 is the appropriate level for the area, despite that we haven't done a full, robust modeling exercise. It's quite a complex system, but the physical characteristics of the lake and surrounding basically does not allow, the levels to go above RL8. And so RL8 is the more appropriate level. in terms of building platform levels, we are recommending that the New Zealand Standard 4404 2010 be adopted, and for that we are basically a freeboard above the flood level for the building platform is 0.5 for residential, 0.3 for commercial and industrial, and 0.2 for non-habitable. And these levels have been confirmed also by APL, I think in Mr. Desai's evidence yesterday. So in that regard, I guess the flooding issues can be addressed. The other flooding basically can occur from local direct rainfall, and that can be addressed through the normal standard stormwater management at the consent stage. The other aspect was the. So, do you have any questions on the APL first? I guess. No.
I suspect not. I'll check with the rest of the panel. Mr. Cooney, do you have any questions?
No, thank you. Thank you, Mr. Bashir.
Mr. Marg?
No, thank you.
Mr. Fulton?
Yeah, just one look. This is just a brief question about the RL. Can you just in very, very broad terms, just tell me what this RL 5.4 to 5.75 and all that sort of stuff relates to? I understand the height, but what is the technical term that actually triggers, or where would you find the definition for this? An RL.
So RL is reduced level, which is basically a reference to Motoriki datum for all the levels in the Waikato.
Yep.
The lake level was set and is regulated under consent to be managed between, so the lake has to be managed between the elevation 5.4 and 5.75. And there are gates on the lake that basically we have to open and close depending on rainfall, river levels, and what happens in the catchment to keep the lake within these levels. And the reason for controlling these levels is that the lake is an integral part of flood scheme where it provides the key, like the main storage, flood storage, in case we have a big flood, an extreme flood.
Mr. Bashir, I think am I right in saying that in
case we have a big flood, an extreme flood?
Just to clarify that, I think Motoriki datum, as opposed to the RL, Motoriki datum is an approximation of mean sea level, is it not?
Yeah, Motoriki datum is the mean sea level. Yeah.
So a 5.4 meter reduced level is a level that's nominally 5.4 meters above mean sea level.
That's right.
Right.
Yes.
Thank you.
I maybe misunderstood the questions. Sorry.
No, that's okay. And I have no questions either. Thank you.
Thank you. So the next one was in terms of the proposed, I think in the submission of Chan's properties, the proposal for a rural residential or country living in the area adjacent to stop banks. The whole area basically is in a floodable floodplain. It is protected by a stop bank, which is a rural standard stop bank. And the technical evidence that the assessment was done presented, basically, it lacks detailed modeling. It also assumes that the flood scheme will adequately protect the site from flooding. And in my opinion, it's not appropriate for this property to be rezoned for more intensive land use in the absence of more specific information on how flood risk can be adequately managed in this location.
Thanks, Mr. Bashir.
And in 3.5, I have reviewed the evidence of Dr. Grant Webby for Mercury, in which he expresses concerns with the potential future development and a cumulative effect of infilling and reduced flood storage in the lake. Dr. Webby requests setting the 1% AEP flood level for the Lake Waikare at RL 7.37. The Regional Council agrees that the accumulative effects of infilling should be closely managed, however, does not support setting 7.37 meter as the 1% AEP for Lake Waikare. And that's because setting flood levels should incorporate climate change effects and other residual risks, and these have not been defined by full robust hydrological and hydraulic modeling at this stage. In my opinion, RL8 is the minimum acceptable 1% AEP level for the lake. This is considering that historically the lake level reached RL8 8.38 in 1958. And that was before the flood scheme was built. So kind of that represents worst case scenario, assuming that in the future, for some reason, councils decide to remove the flood protection from the area, then we would expect the levels to reach 8.38.
Thank you.
In terms of the Section 42A report, I agree with the statements around flooding for 41, 42, 40, 43, 45 of Section 4.2 of Ms. Reynolds' report. However, in terms of Statement 44, specifically, basically using the term finished floor level instead of the recommended NZS 4404, building platform level. And I have explained the difference between these two, I guess.
I think we understand that. Thank you.
So I guess without further ado, I'm done.
Let's see if there's any questions. Thank you. Mr. Mayo?
None from me, thank you, Mr. Bashir.
Mr. Fulton?
No, none from me, thank you.
Mr. Kearney?
No, thank you.
No, and I have no further questions either. Thank you, Mr. Bashir. Thanks for your evidence.
Thank you.
I think we might take our afternoon break and we'll recommence at just a fraction after 3:15. Just a reminder not to, that gives us a quarter of an hour, not to put too fine a point on it. Please don't log off, just mute your screen. Thanks if you can. Thank you, everyone. We're resumed. Mr. Lanning.
Thank you, sir. Next witness is Mr. Kaur, dealing with public transport issues.
Thank you.
Okay. Good afternoon, Chair and panel members. My name. Sorry, can you hear me?
Yeah, we can. Sorry, I just said good afternoon.
Okay, sorry. Yeah. So my name is Vincent Kuo. I'm a transport policy advisor with Waikato Regional Council. I'm here today to present my evidence in relation to Embry's rezoning proposal for public transport on public transport matters. So just with your permission, I would just like to take my main evidence as read.
Yes, thank you.
And I'll just quickly read out my summary of evidence that I've submitted, and happy to answer any question afterward. So if we can just jump into paragraph 1.1 of my summary statement, my summary evidence. In my view, there are strategic and operational reasons as to why regional council is unable to provide a public transport service to the proposed development area at this time. This includes the site is not located within the existing growth area identified under the future-proof strategy, and accordingly, council has not undertaken any forward planning or detailed assessment to ensure the strategic integration of land use, infrastructure, and service provision. The proposal does not align with council's current strategic priorities and objectives set out in the regional policy statement, regional land transport plan, and regional public transport plan, particularly with respect to promoting multimodal transport connection and reducing reliance on private vehicles. It is not cost efficient for council to provide a new public transport service due to likely low demand, higher operating costs, which will lead to higher opportunity costs. I think the implication here is that the resources would need to be redeployed from other planned areas. Whilst the existing bus services could be connected to the development side via the proposed interim bus stop, these services will provide very limited utility due to low service frequency, and will offer limited benefit in terms of providing transport choice and reduce reliance on private vehicles. In my opinion, any additional and enhanced public transport service to the development side will be contingent on a new and sustainable funding source being found outside of the existing council and Waka Kotahi funding streams. This will require a new funding framework or mechanism to be developed and agreed by the councils and the applicant. It is also my opinion that even if a more frequent bus services could be provided to enable people to access employment, education, and essential services, the critical issue is that this development by its location will incentivize car-based journeys over other transport modes. So I think this just pretty much sum up my main evidence, and I'm happy to take questions.
Thank you, Mr. Kerr. Mr. Mark, do you have any questions?
Just one, Mr. Kerr. Can I just clarify with you, did you say that from a not cost efficient point of view that there was a low demand?
Yes. So
when you say, oh, sorry, Carol.
Yep. It's just, I think there's some uncertainty around the future growth in the area. So whilst we understand there will be potentially 1,100 households provided, but it doesn't really warrant, I guess, a good sort of public transport service in terms of, creating that economy of scale.
Okay. The evidence we heard today around modelling around 1,100 residential houses times 10 movements on a daily basis that would be quite significant. As from a use of a private car, that would say the demand is quite high for going onto the expressway.
I guess I also need to add in terms of, I think in my evidence I've sort of highlighted that in terms of the site being located next to the expressway and have easy and convenient access to roading network, this potentially has issues in terms of, I guess, to incentivize people using public transport. So that would be one of the factors that it's likely there would be population, but in terms of demand, I don't think it will be that great.
So the common phrase that's been used, car-centric, you wouldn't see that as actually a big deal?
No, I think in my evidence, I've sort of touched on this issues. I think for RPS and other regional transport planning documents, they all speak the same language in terms of wanting to move away from car-centric development. So wanting to promote more compact urban form, which can make public transport provision more viable, and also encourage multimodal connection and reduce the need to travel. I think that's probably the guts of the relevant provision in the RPS and ROTP that's relating to PT.
Oh boy.
Thanks, Mr. Mark. Mr. Fulton?
Yeah, just one question. The the funding mechanism you mentioned would need to be more enhanced than what the Regional Council and the Waikato District Council might put together, but that wouldn't exclude Ambridge from being a contributor to a service. Is that correct?
Yes. So my understanding is that from a regional council's perspective, the expectation would be that the cost of PT needs to be funded by the developer or development. So I think the cost of the cost of providing public transport service should be borne by the development. Given that the reasons have outlined that council probably not in a position to provide public transport at this time. Also, there's significant funding challenges that council face in terms of needing to prioritise services for future growth area.
Yeah, I suppose, and you'll be aware, I was on the Regional Land Transport Committee and understand a lot of the stuff and understand, I think, where a lot of it goes. But you can say Pocono was an example where there was no funding or no mechanisms up there, but that developed over time because of demand. Don't you think that the same thing could apply here? Not isolated.
That it's potentially an example we are trying to avoid because in terms of Pocono, so we know that the growth has happened rapidly over the last 5-6 years, but there wasn't any sort of proper PT planning done in advance of the development. So as a result, like we are having to play catch up. The regional council ended up in a position to play catch up. So over the last 3 years, we have worked quite hard in terms of coming up with a proposal, getting a proposal approved and secure the funding. And only this year, I think we are about to go out to tender this year. So just thinking about the missed opportunity in terms of having early public transport, like from day one, and particularly for a site like Pocono, like people will have to rely on private vehicles and expressway to access service and jobs and education. So I think there's potentially a missed sort of opportunity in terms of integrating PT at an early possible sort of development timeframe.
Okay, so lessons learned there could help here. Okay, thank you very much.
Ready? Ready. Do you have any questions, Mr. Cooney?
There's a bus service going up to Te Kawhata, is that right?
Yes, correct. Yep.
And is that same bus go to Pocono?
No.
Okay. The bus that goes to Te Kawhata goes past Ohinewai?
Yep, so that's a daily return service. So it starts from Te Kawhata, I think around 5:45, and stop at Ohinewai at 7 a.m. in the morning. And the return trips, I believe it start from Hamilton around 5:30-ish in the evening, and probably arrive Ohinewai late around 6:30. Yep,
so it currently goes into Ohinewai, does it?
Yep, but it stopped at the western side of the expressway, so by the community hall.
So the issue is simply it stops on the western side instead of the eastern side?
Not necessarily, because I think that service was designed specifically for Te Kawhata. So even if we, because I think I've outlined my evidence, I think the usage will be quite limited with Embree's development, given the timetables and very low service frequency. So I wouldn't say that that's a effective PT solution. So essentially, the community will get 1 return trips per day, but it's quite constrained in terms of the timetable.
So to make it work, you'd need to put on more buses and have a larger timetable, and the bus would go across to the eastern side, would it?
Yeah. In terms of making public transport relevant, like you need to look at more enhanced public transport services over and above what's being provided existingly.
That doesn't seem to me to be a difficult situation to achieve, is it?
I think the problem, putting all the strategic issues aside, I think the fundamental problem is around funding, and also the fact that, yeah, I think it's mainly around the funding issues. So council is operating on a tight budget, so we have to prioritise. And based on my assessment, I don't think this proposal will rank highly, against our internal prioritisation process.
If the region gets a $200 million benefit per annum, this issue is small beer, isn't it?
I guess there are two parts to this issue. I think operationally, yes. I mean, for public transport, like if you throw enough funding, certainly you can get much improved outcomes. But in terms of principles, there's still some principles in terms of, do we encourage development to happen outside of existing growth area, knowing that it's much costly to service. And so I think there's probably two elements to it.
Okay, you got a corridor study going on at the moment as to where future development should go, etc. So under that approach, then it's a pretty limited study, is it? Because you might have to catch a bus.
Sorry, I'm not sure I understood your question.
Well, you got a corridor study going on at the moment. You're saying it's an important principle that we don't have new development along that corridor because it.
No, I'm not saying. I'm just simply suggesting that, whether the development is happening at a location that could be mostly efficiently serviced by PT. So, for example, if the residential component is in Huntly, like certainly we can make PT more efficient. Like we can utilize existing bus fleet. We can enhance the service quite easily. That can also provide broader benefit for the Huntly township. So I think it's not just simply saying that we against growth. It's just the location of growth that needs to make sense.
Okay, thank you.
I don't think I have any questions. Thanks, Mr. Crowe. That's clear enough. Thank you very much. Mr. Lanning.
Slide back into the cameras there. So the next witness is Dr. Hackle.
Thank you.
Good afternoon.
Good afternoon, Dr. Hackle.
Good.
So I'll just start with some key points that I want to make and then have questions, if that's okay.
That's fine, thank you.
Okay. So my position is grounded in an analysis of the APL material and in the recent local experience of Te Kauwhara. And my position is that there's a high risk that Ohinewai will at least primarily become a dormitory town. Mr. Quigley's SIA refers to interviewees he engaged with that identified Te Kauwhara as a dormitory town. Because residents travel to Auckland and Hamilton, not only for work, but to school their children, to socialise and to shop, with the flow-on effects being that residents do not participate in the local community. Dormitory towns create a number of social risks associated with a lack of community cohesion, car-dependent lifestyles, and can lead to reduced opportunities and social isolation. Without affordable housing, those working at Ohinewai will not be able to afford to live there, and the majority of the housing will go to residents who work elsewhere. The affordability of the housing is uncertain. According to the APL material, the majority of the housing will be sold on the open market and will be at a price point that is not affordable to the employees of the industrial component. Dr. Fairgray's analysis of the housing affordability suggests that for 60% of the employees of Sleepyhead with incomes of $45,000 to $46,000 after tax, the maximum affordable price is around $350,000. He concludes that for the OSP to contribute to affordable housing, there would need to be a significant number of dwellings in that lower range. It is not established in the Quigley and Watt CIA or elsewhere that the minority portion of housing subject to the rent-to-own scheme will be affordable. Given the proposal makes much of this social benefit, it's unclear why there is not more content about this crucial dimension of the live, work and play concept. According to Dr. Fairgray, given the lack of specificity about the affordable housing provisions and how they will be implemented, the numbers of dwellings which will be released to the open market rather than be affordable dwellings dedicated to the comfort group workforce, it is difficult to be confident about the likelihood of the whole Newtown development proceeding, even if the approval is achieved. On the one hand, there is an express commitment to affordable housing, and yet the majority of the housing will be sold on the open market at a price point of $480,000 to $550,000. This makes only a minority portion of the housing potentially affordable to the employees of the industrial component. I say potentially because there is no information provided about how affordability is to be achieved for that minority portion. Apart from an unspecified rent-to-own scheme in Mr. Quigley's SIA and staircasing in Mr. Gaze's. The lack of specificity about the affordable housing provisions so far makes it very difficult to be confident that the housing plan for Ohinewai will be affordable for the employees of the industrial component. Without the affordability component, the risk of a dormitory town is high. There is no question that the employment offered by the industrial component will have substantial benefits. However, the social benefits of employment can be amplified or degraded by the affordability of the housing and the quality of the social infrastructure that supports the community. It is important to recognise that employment is only one aspect of a person's most important life priorities. Understanding the requirements of the workforce and their families would be critical to establishing whether the residential component would be attractive and affordable to employees. This is also why the decision to exclude the perspectives of current Sleepyhead employees is questioned by me. The reasons given for that exclusion by Mr. Gaze and his rebuttal evidence are: it is too early to canvass the proposals with employees, and there is plenty of time to ascertain the interest of existing employees in moving to Ohinewai once we have consent. The proposal is being debated in the news media, and employees of Sleepyhead would be well aware of their employers' intentions. Understanding their interest, concerns and requirements would be an important source of information for the SIA. The exclusions of current Sleepyhead employees considering moving to Ohinewai, the parents of children at the primary school, as well as the underrepresentation of current residents in the SIA, obscures potential negative social effects, because these are the groups we might expect to have both greater personal interest and greater concerns about what is being proposed. The proposal also includes a minimal level of social infrastructure, and Mr. Quigley is clear that the development is not intended to be self-sufficient, but rather Ohinewai will be part of the social context of Huntly and Te Kaupata. Given the distances between Ohinewai, Huntly and Te Kaupata, there would need to be some enabling social infrastructure to ensure that residents can easily access opportunities to be part of the social context of Huntly and Te Kaupata. The proposed walkway, cycleway is positive in this regard. However, the land is not owned by APL, making the proposal uncertain, and the long distance makes it less likely that it will be well used. In my view, more would need to be done to enable Ohinewai to be part of the social context of Huntly and Te Kaupata, including public transport that responds to the needs of the whole community for access to the social context of Huntly and Te Kaupata. Bearing in mind that lower income residents have fewer leisure opportunities and rely more heavily on local social infrastructure, such as community meeting places, libraries, public transport and local clubs. The plan lacks consideration of this social infrastructure needed to create a sense of community in a new town that is not designed to be self-sufficient. I agree with Matthew Jones' view that the proposal lacks a central community meeting place. While workers who live at Ohinewai may not have to travel to work if they work on site, other members of their households will, and because Ohinewai will have limited social infrastructure and is not self-contained, access to shopping, schools, health and other services and entertainment requires car journeys. This imposes travel costs on residents that will impact negatively on their cost of living. Dr. Fairgray's analysis of the retail service node based on Mr. Heath's estimates indicates that the on-site retail would service 1/5 of Ohinewai's household demand. Ohinewai households would need to access 80% of their goods and services from Huntly or Hamilton, meaning that Ohinewai residents will need to travel outside of Ohinewai to access the majority of their basic needs. This creates a car-dependent lifestyle that has negative social impacts, including poor health, restrictions on the mobility for children, teenagers and older persons, as well as those who do not have access to a car, and can contribute to the exclusion of these groups from access to opportunities for full participation in social and economic life. According to Mr. Quo, not just the relatively remote location, but also the layout incentivizes car journeys. In terms of social connection within the proposed residential development itself, the likelihood of a car-dependent lifestyle would restrict casual interactions among residents. Casual social interactions are an important ingredient for connected communities who enjoy many social health benefits increasingly recognised in public health literatures. The disconnection from the existing Ohinewai settlement would also contribute to this lack of community cohesion. The car dependency of the residential development means that there is no pathway available to reduce carbon emissions. This is an important consideration given climate change mitigation is now urgent. With so little information about the affordability of the housing or how it is to be achieved, there is a risk that the master plan will only be partially completed because the affordability component may not be affordable for the employees or for the developers. There is a reasonable potential for the partial development of the plan change area, and this has the potential for adverse social outcomes. And I agree with Ms. Healy that this makes the findings of the SIA limited in respect of the potential outcomes of the plan change. Without the full completion of the proposed social infrastructure, the places that make healthy living possible, the meeting areas needed to facilitate community connections, the risk of social isolation and associated harm increases. Thank you.
Thank you very much. Let's see if there's any questions. Mr. Cooney?
No. Well, have you nowhere in your evidence do you mention the letter that was attached to someone's, Mr. Gaze's evidence, showing a real estate agent saying that he had a client who wanted to buy 10 hectares plus have an option on 200 houses. That's not consistent with sort of open market that you've said will probably eventuate, is it? And we've heard evidence from Mr. Turner that they haven't even gone to the marketplace yet. So if that's representative of what could happen here, your concerns go out the window, don't they?
I don't think they go out the window, sir. I think that my assessment is based on the information that's been provided by APL, and that is that the majority of the housing will be sold on the open market.
But people are going to, that's an example of work, live and play, which is promoted in the future-proof strategy.
The work, live and play concept can only occur if the housing is in fact affordable, which has not been established.
Well, it's a matter of evidence, isn't it? Okay, thank you.
Mr. Mark?
No questions from me, thank you.
Mr. Fulton?
Just one question. Referring to the development being a dormitory town, I expect you'll be familiar with the lakeside development in Tikawhara, and I would, in my view, probably consider that could be a dormitory town as well, because it's 2 kilometres from the Tikawhara village, and they'll have to use their transport to get there. Is that, would you say that would be a similar scenario, lakeside development?
I'm not completely sure of that, as I'm not completely familiar with that, but Te Kauwhara is identified as a dormitory town in the SIA.
Okay, thank you. Finished. Thank you.
Thank you. I don't think I have any questions. I mean, there's obviously differences of opinion between you and Mr. Quigley, but I think you've explained the differences, and I think me asking you questions about them won't assist in my understanding. We've obviously got 2 points of view that we're going to have to grapple with, so I don't have any questions, but thank you for your evidence, Dr. Hackle.
Thank you.
Barry, I had trouble following that statement because it appeared to be being read, but it wasn't the witness's statement of evidence or her summary. So I just wonder if you can help us with that. There may be a document we've missed.
No, that was just a summary of my 3 main points that are in my.
Okay. Thank you.
I think, given that it looks like they're neatly written and so on and so forth, and they seem to be a lot more than speaking notes, as it were, and given that we have, as a panel, relied on pre-circulation in the most part, it would be helpful if you could make those available to Mr. Bell, please, so that we can at least have the benefit of them in writing,
Yes.
rather than having to go back to the transcript or to the video recording.
That's fine. I can do that.
That'd be great. Thank you very much.
So the next witness is Mr. Keenan on economics.
Thank you.
Tēnā koutou katoa. Can you hear me all right?
Yes, we can. Thank you. Thank you very much, Mr. Keenan. Just when you're ready.
Okay, so I understand I can take my evidence and summary as read.
Not just that you can. That's what we require you to do. Thank you.
Thank you. So really, there's only a couple of issues from those documents that I want to highlight. The first one is, I guess, my concern about whether there's some overstatement in the benefits that we've seen from some of the other experts. And I'm talking particularly around a reference I saw, which I think Mr. Osborne has used, but it came originally from Dr. Wheeler, around $8.5 billion worth of benefits over 10 years. Dr. Fairgray, in his latest report, pointed out that there was some confusion in relation to Dr. Wheeler's report as to whether he was talking about a value-added measure, such as GDP, or a gross output measure, because these are 2 very, very different things. Gross output is invariably much larger than the value-added concept. Doing some sort of calculations on what it would mean to get $8.5 billion over 10 years suggests that we're talking about 1.1 billion per year over 10 years. So, and then when you calculate that as a net present value, it comes out at 8.5. Given that that would imply a 40% increase in the GDP of the Waikato district from this one site, that seems implausible to me that we're talking about a value-added concept. If, on the other hand, we're talking about a gross output measure, then as Dr. Fairgray points out, there's a lot of double counting that goes on in those measures. So to infer that that is a quantum of benefit is to overstate the benefits of the development quite considerably, in my view. The second issue that I wanted to raise was around uncertainty. I've heard it said several times that that we're demanding an unreasonable level of certainty, whereas from my perspective, the evidence that's been put forward, which is around the full implementation of the master plan, in fact, it's a single outcome amongst the range of possible ones, so it's inferring a false sense of certainty, if you like. And perhaps I can give a couple of examples of why I think there may be uncertainty around these outcomes. One is in relation to affordable housing. So, as previous witnesses have said, there have been some allusions to how affordable housing will be delivered, but it's not very clear how that would work. Now, yesterday I heard that houses would start at around 480,000. Using the formula that I did used in my evidence, where I looked at a price point of 400,000. So I've just done some calculations to see what 480,000 might look like. And if we assume a current interest rate of mortgage interest rate of 3%, which is very, very low, and a 30-year term, a $480,000 house would require an annual income of about $82,000 to be affordable. If you were able to scrape together a 20% deposit, then you're talking about something like an annual income of $65,000 that would be required. Now, it may be that my definition is not the one that's being used, and I know that another approach is to say that the housing that's being provided is more affordable than Auckland, and I have no trouble with that assertion whatsoever. So the question, I suppose, is that if we're talking about making those houses affordable to relatively low-income workers, that's going to require a lot of additional subsidies in some form or of another, whether it be shared equity schemes or other things that have been mentioned. And if we're doing that over hundreds of houses, it pretty quickly builds up to tens of millions of dollars. And so I guess I wonder what kind of implications that may have for whether the entire master plan is still feasible to be developed. The other question that arises for me, and I'll leave the question of whether you can be confident about water and wastewater infrastructure to others. So all I would say is that if there's some doubt over whether those services are certain, and sorry, I am asking for some certainty here, then if it's a non-zero possibility that these services can't be provided, then there's a substantial chance that some of these benefits cannot be realised. That's all I had to say for now, so I'm happy to take questions.
Thank you, Mr. Cannon. Mr. Fulton, do you have any questions?
No, no questions. Thanks. Happy with that.
Thank you. Mr. May?
Tēnā koe Blair, no questions from me, thank you.
Mr. Kearney?
Mr. Keenan, you're critical of the 8.5 billion by assessment over 10 years by Mr. Wheeler. Mr. Osborne has said that if this development comes to fruition, the master plan is implemented, we could expect 200 million per annum economic benefit. Do you agree with that?
Yes, and I think I've made that quite clear in my evidence, that I think there will be substantial economic benefits, whether it's 200 million or not. I had some questions which I've raised in my summary around table 5 from Mr. Osborne's work, where he identifies $222 million worth of benefits, but the line items in the table only sum to 126 million. So I simply don't know what the gap is. But my short answer is yes, I agree that if the master plan is fully implemented, then there'll be substantial economic benefits.
Thank you. Okay. Thank you, Mr. Chairman.
Mr. Cooney?
Thank you.
Oh, sorry, I didn't hear you. I'm sorry. I've just got one. I mean, obviously, any economic assessment looking forward is prone to assumptions and different interpretation. I think everybody accepts that, the experts included. Mr. Osborne, I asked him in terms of relative terms, what would it be that this development is most closely comparable with in an economic sense? And he said it was, he thought it was something around about the scale and extent of a large-scale Fonterra dairy factory. Is that, and leaving aside what that means in absolute number terms, does that sound about right to you?
You're asking me to speculate a little bit here, but I have no reason to disagree with that.
Okay, no, that's helpful. Thank you. And thank you for your evidence. It's very helpful to us. Thank you. Mr. Lanning, just before Mr. Mayhew starts, just for to let Mr. White know. Are you there, Mr. White?
Yes, I'm here.
Just to help you with your thinking in terms of where you're going this afternoon, I think it's very unlikely that we'll get to you today. So just to let you know that we'll start with you in the morning, just so that you can probably relax a little more than you might otherwise have. But not that we're trying to stress you or anybody else, but we'll see you in the morning. Thank you. Thank you, Mr. Lanning.
Thank you, sir. The final witness is Mr. Mayhew, who is, of course, giving evidence on behalf of Waka Kotahi as well as the Regional Council.
Thank you.
And he is somewhere else, so but I see him on the screen somewhere.
Thank you. Good afternoon, Mr. Mayhew.
Good afternoon, kia ora, panel. Sir, I'll just run briefly through my summary statement. Being one of Mr. Berry's old guards, it's a paper statement, and so I'll be working through that. Okay, so my evidence outlines a range of issues in respect of the proposal in front of you today. And I'll just tick through those briefly. The first is the issue of potential cumulative effects associated with the development and other potential developments, as you would have heard from Ms. Shedd today, around case law, around the need to consider cumulative effects and what may also happen. There's other areas here that are identified for potential future development and obviously other interests from OLL and others. I guess the Council and Waka Kotahi's concerns are primarily around ensuring that infrastructure is identified and is provided for, consistent with a number of policies in the plan, policy 6.1 in the RPS, for example. You know, I noted yesterday in the evidence of Dr. Wheeler, he indicated that there is, you know, a good ways now of allocating, proportioning costs across developers. But I guess that's predicated on understanding what those costs are, having an idea of what that future development might be, and then having some mechanism to ensure costs are shared across developers.
Sorry to interrupt, Mr. Mayhew. We're having trouble hearing you. I
sorry.
think it's you're cutting in and out. The video looks strong, but I suspect it's to do with where your microphone might be relative to the moving parts.
Oh, it's is that better?
No, not really.
Oh, okay.
I wonder if you might be able to try it without the headset and see if that improves things. Is that feasible? Is everyone else having the same difficulty, or is it just me?
Is that better, sir?
That's a lot better. Yeah, I can hear you perfectly now.
Okay, sorry about that. I might also take the opportunity just to take my jacket off, because
as long as that's as far as you're going, that's fine.
That's all we get. So as I was saying around the infrastructure and just ensuring that infrastructure is provisioned and it's appropriately identified and provided for. And, you know, we've talked about examples, for instance, where there might be some upgrades to transport infrastructure, bridges, things like that. And they may be triggered by cumulative effects and other development in the area, and just understanding that. The next issue that I highlight, and I'm sure you'll come back to this with some questions, is around the assessment of alternatives in respect of 32AA of the report, which really only looked at different options of how the plan change may be taken forward. In my opinion, the extent of the departure, and I appreciate that, is provided for by the RPS, but also the potential implications for public funding, to me justify that there should have been a more extensive consideration of alternatives, and that, you know, to understand some of the decisions that we hear and whether there are alternatives and associated risks of acting or not acting with that. Others have talked about the case law around plan changes and whether that's required for a plan change. The next one is the issues of the site and suitability for development, particularly in relation to the residential component. We heard yesterday it's a very difficult site to develop. Understand that. It's exacerbated severance across the expressway, particularly with the school. The ability to effectively service it by multimodal transport nodes, transport links to and from the site. Being developed in a floodplain which requires substantial filling and so on, and issues like that. Now, I appreciate that many of those issues have been mitigated. I guess the issue that I have is at what point does this affect the issue of affordability and go to really what is the core of the comfort group's proposal around live, work and play in this area, and you've just heard from Dr. Hackle about that issue as well around that. And, you know, is that a reality in a site that is requires substantial mitigation? I'm not saying that any site's perfect, by the way. I think, you know, that's certainly an issue, but there are certainly a number of matters here with some significant mitigation. Effects on transportation network, I think that's adequately covered by Ms. Loynes. Water and wastewater servicing, you would have noted in my evidence and my summary that I still have residual concerns about that issue. It's obviously a very important issue and fundamental, particularly to the residential component of the development. The Mid-Waikato surfacing strategy is pretty new, and it's identified some engineering options that are available and which one might be the preferred option. And so that part of it is assessed, but I guess, and some costing associated with it, of course, but the issue for me is really about what's the outcome that's going to achieve, and particularly in terms of the vision and strategy and effects on the Waikato River. And also about, because that leads to affordability. Is that system, as it's designed, realistic that it would achieve the outcomes in the regional plan, particularly PC1, and also the vision and strategy, and what is the cost of that, and is that cost appropriately allocated? So I
I personally don't think that that requires a huge amount of analysis. I just think it needs to be gone through. And I still consider that there are concerns around water allocation issues. I find it a little bit confusing, I have to be honest, around what the options are and how they are and where the consents sit and the viability of consents. And there does seem to be a little bit of difference in the various documents. Coming back to this issue of certainty, you know, I note, and I'll just read from this, is the recent guidance from the Ministry on the issue of responsive planning. And it talks around that private plan change proposals should show that the infrastructure needed to service the development would be provided. This could occur in a number of ways, including local authority agreeing to amend their relevant infrastructure plans, budgets and financial policies. The local authority and landowner entering contractual agreements with the relevant infrastructure providers to enable the direct provision of development infrastructure and ongoing ownership and maintenance requirements, or establishing a special purpose vehicle to finance infrastructure under the Infrastructure Funding and Financing Act. And in my opinion, we're not quite there yet. Mr. Cooney has asked some questions around the difference between the old MPS UDC and the MPS UD, and looking at the section 32 assessment of that, it talks about, sorry, I just need to find it in front of me. The policy intent is to expand the existing MPS UDC provisions to make it more explicit that planning decisions should be coordinated and aligned with infrastructure decisions. And there is an element of that in terms of staging and things like that. I guess the question that I have is that certainty, particularly around funding and outcome, sufficiently understood to progress with the zoning at this stage? And just touch on the certainty of outcomes, and I'm not taking away from the Comfort Group's vision of what it wants to see in this development, but I think we all acknowledge that there are a number of matters that need to be taken a little bit on faith around that they're not easily secured through plan provisions and issues like that. So affordability, I've raised the rail link before. I know that Mr. Oliver addressed that in his evidence as well. Public transport, and there are a range of things that we are being taken on, asked to be taken on faith, that they don't lend themselves particularly to provisions. And so just, I think when we're looking at this, it's in particular that that we are approving the structure plan, or that's what you've been asked to do, is approve the structure plan, not the master plan. And so I think we just need to keep that in, or panel needs to keep that in mind as we go through. Just turning now to the National Policy Statement for Urban Development. That's in my evidence, I won't get there. There is just one issue that I felt I didn't adequately address in my evidence there, and I would just like to deal with that issue now. And that is the matter of responsive planning. And in particular, Policy 8 and subclause 3.8 around it, and unanticipated and out of sequence developments. I didn't really address that. I just want to acknowledge that I do think that that does apply in this circumstance. Policy 8, local authority decisions affecting urban environments are responsive to plan changes. So I certainly acknowledge that that exists, that is relevant. And accordingly, section 3.8, I think it's in the 3.8 itself, as Mr. Oliver explained, requires regional councils to include criteria in its policy statement for what is determined to be adding significant development capacity. I think it's reasonable in the context of where we are now that it can be assumed that this proposal in front of you does provide significant development capacity in the context of where it is at the moment. And that leads me then to the issues of subclause 2 of policy 3.8 around contributing to a well-functioning urban environment and its connection across transport corridors. So I didn't address that in my, my evidence there, and I just wanted to make that clear.
Thanks.
Just turning to the vision and strategy for the Waikato River. Vision and strategy. I guess the issue here, to me, is closely linked with the water and wastewater provision issues. I entirely accept that if the master plan is developed as it's proposed, there are certainly elements of that that contribute to the objectives of the vision and strategy. I'm not the best person to talk about that. I'm sure you'll have other evidence on that. But my concern is really is just ensuring that from a water and wastewater perspective, that there is a reasonable solution that is likely to achieve those. I don't see that that's actually difficult to do, to be honest. I think it's, you know, there is a design for a treatment plant. They must know what the output performance is, what the design parameters are, what the level of removal is, and things like that. So I would have thought it would be not a not trivial exercise, but not very difficult to understand whether the fundamental, what I suggest is the fundamental basis of the vision strategy, which is about improvement, can or cannot be achieved. And if it can't be achieved, then it seems to me that the design needs to be reviewed in terms of that you can always bolt on more to a treatment plant and achieve a higher level of performance, albeit at a greater level of cost. So to me, those issues of performance and cost, is it going to achieve the outcomes? I think should be the starting point for that. Is it going to achieve those outcomes at a very simplistic level of improvement? And what's the implication of that? Next issue, just very briefly touching on, because I'm sure the question on it is just the regional policy statement. There are obviously a lot of provisions in there that have a range of matters to be considered, things that should happen, things that shall happen, and all of those sorts of issues. And I'm happy for you to raise those ones that you would like to discuss in your questions. Next issue I want to talk about is flood risk. I'll only touch that briefly. It seems to me that the issue of flood risk has been resolved. I'm not totally convinced that there is a exact alignment with the words, but I think that can be nutted out should you move to a stage of looking at more detailed provisions. Black mudfish, I know that issue was raised before around that. As per the evidence of Dr. Wilding and others, this isn't a site where there seems to be large numbers of mudfish. We're not saying this is an enormous issue. The only thing that I would add from a planning perspective in relation to the management plan, though, is, in my opinion, the RPS does direct protection where it's feasible to do so. And to me, that should be the starting point, if it is feasible, of any management plan. Is it feasible to protect that habitat? Realistically, if it isn't, then I think that the next step is looking towards some translocation or offset, because translocation is unlikely to be successful. Again, I don't think that's a particularly big issue around that. Other documents, I think the weight has been discussed in various stages of things. The only other issue that I just wanted to be clear on was I did raise some issues relating to reverse sensitivity. As you would have seen from my summary evidence, having looked at Mr. Oliver's response to that and also the section 42A, I'm satisfied that those issues can and will be adequately addressed through both the OSP provisions and other provisions in the wider plan. It does, raise some issues in respect of what Mr. Oliver was talking about. How do you adopt some plan provisions into the a standalone precinct plan? Obviously, one of those would be in relation to a major hazard facility. So I think there'd have to be some thinking about which ones and which provisions may or may not be introduced and which other ones won't.
I think that probably, sorry, just a couple of issues. I did provide some thought around the importance of the staging if it's to go ahead, notwithstanding my views that the water and wastewater isn't quite there yet. I have suggested that there are probably some ways of perhaps putting greater emphasis on that through the process. I am a little bit concerned, not inconsistent with the issue that you raised, is discretionary activity to go past staging issues is potentially not a challenging process, and it's particularly as we go through that the existing environment will change, and so applications will be compared against the existing environment in that. The other final issues, and I confess I am a little bit confused just around the status, and I'd be happy to have your direction on this, Mr. Chair, is just around the Shands property. I understand that it is still on the table in terms of a rezoning. Is that correct?
I stand to be corrected by council staff, but my understanding is that the proposal is still live, but that they are not proposing to call any further evidence beyond what's in their submission and further submission if they've made a further submission.
Thank you. That's
my understanding, but I'm just wondering if perhaps Ms. Trenouth or one of the other council people could confirm that for us.
Good afternoon, Mr. Chair, it's Chloe Trenouth.
Sorry, Ms. Trenouth, you're very faint.
Can't hear me? Sorry, I've got
Can now, that's better, thank you.
Okay. I'm not aware of the Shands withdrawing their submission, so my understanding is yes, as you've indicated, it's still live. They've got their technical evidence, but no presentation to the panel.
That's my understanding too. Thank you for that.
In that case, sir, you've just heard from Mr. Bashir around that and his concerns as to whether the issues of flooding have been adequately addressed, how that might be managed on that site, and my caution is just to ensure that just because flooding is addressed through the APL proposal, that does not necessarily transfer itself to the Shan property. I'm also slightly confused around where the Ohinewai Lands Limited proposal is. I read the evidence to suggest they weren't seeking a rezoning of their land. That doesn't quite seem to be the case around that. But look, I think that really it's to us, or to me, it's really an issue around, this is an indication of the potential for cumulative effects that ideally would be considered through this process so that we can ensure that if the proposals are to go ahead, that the appropriate requirements for infrastructure are identified and funded and apportioned across those developments. So that's my summary, sir. I think you probably prefer to spend the rest of the time on questions.
All right, thank you, Mr. Mayhew. I'm sure there are some questions for you. Mr. Marg, can we start with you, please?
Yeah, kia ora, Mr. Mayhew. In relationship to you adding the NPS on urban development responsive planning, are you able to clarify, are you suggesting then, if we were to go to section 3.8 of subpart 2, that any unanticipated or out of sequence developments are you now saying with the structural plan that this would be enabled within the plan itself?
Enabled? No, I'm saying that so district plan is required to give effect to a national policy statement and also a regional policy statement. I was simply saying that I think that was one of the provisions that needs to be considered in having effect to the regional policy statement, to the national policy statement that I hadn't covered in my evidence. I don't think, to me, that doesn't supersede the requirement to consider and give effect to the regional policy statement. There are some issues around if they conflict, I accept that. But it was just simply to point out that I had omitted that from my statement.
Okay, thank you. No other questions from me, thanks.
Thank you. Mr. Fulton?
No, I don't have any questions. Thank you, Mr. Mayhew.
Mr. Cooney?
Yes, good afternoon, Mr. Mayhew. You filed a 77-page brief of evidence on planning issues, and it covered a wide range of issues. And I think, for example, on the black mudfish, I think you had 13 paragraphs addressing that issue. So I really want to get to the gist of your position, which is this should be turned down. Can you just tell me, out of that 77-page brief, what are the showstopper issues that you see are the reasons we should decline this whole application?
Yeah. Okay. So those reasons are based primarily on the technical evidence that's provided by the experts for council in Waka Kotahi in the context of the national policy statement and also in respect of the RPS. So looking at the RPS provisions in particular around that and the development principles, I mean, my conclusion there was, and it's an overall conclusion, I take your point that you've made to other witnesses that it's not a tick box and that you add up the ticks and the crosses at the end of it. It's a decision that is made primarily on the basis of those development principles and in relation to the policies around protecting the benefits and functions of significant infrastructure. You've heard from Ms. Loynes around that today and those issues around that. I do just want to address the issue of, you know, at the time of writing that, there was an all or nothing approach. Sorry, that's how I interpreted it, possibly incorrectly.
I know, I'm not critical of you, because I think we were all of that approach, of that view to start with.
Yeah. While I look at that, when I look at the evidence that's been provided around those issues, and I look at the statutory framework, in my view, the primary issues that have been raised by council's experts relate primarily to the residential component. And we look primarily at the benefits and the economic benefits. It relates primarily to the industrial component. I accept it's not as simple as that, and I do understand that there are interlinkages and issues like that. But I think when we're talking about the numbers and things like that, it's primarily associated with the industrial development. Had that been on the table around that, then I may have come to a different conclusion, particularly around the industrial component.
What's your view now?
In terms of the industrial component, as I say, I think primarily if you're looking at these issues, and particularly this issue of risk of acting and not acting, I think it's accepted by all parties, and you've just heard from Mr. Keenan around that the benefits are substantial. There might be some debate around exactly what they are, but it's pretty speculative anyway. But they are substantial. I think there's more certainty of outcome associated with the industrial component, and certainly based on the evidence of various council witnesses in particular around concerns around the residential partial development, that the idea of resident worker type people may not occur in all of those issues. And also around that lesser in terms of environmental effect and more consistent with the function and benefits of the expressway, which, as has been stressed to you by Ms. Sheard and Ms. Loynes, is around rapid and fast transport of freight for the economic development of the Upper North Island, really, golden triangle, as it's called.
So we're really focusing on the residential component as your current thinking as the reasons for declining this proposal.
I certainly think that that's the area where the effect is the effects predominantly arise, or potential issues, and the inconsistency with the direction provided in the regional policy statement.
So, what are those effects from the residential component in your view?
Well, Ms. Loynes talked about the potential cumulative effects on the benefits and functions of the expressway, and in terms of the context of the framework and the policy framework, it is, to my mind, it is more than just about adverse effects. It's actually about the function and benefits and values of the value of that infrastructure and the investment into that and protecting that value. So I think that's higher than mitigation of effects. Ms. Loynes talked about cumulative effects and the potential for cumulative effects that may ultimately, affect the ability to deliver on the economic benefit that major infrastructure was developed to serve. So I think that's a key one. I think there's quite a bit of uncertainty around the benefits, as Dr. Hackle referred to, around the issues of the social outcomes that are there. I guess it's an issue where there is a picture that's painted of the master plan as it's fully there, but Dr. Hackle is concerned that things might not turn out like that. There might be a dormitory town issue, which will, of course, increase travel and things like that. And just in that sort of context, and the issues of essentially what is a car-dependent development. So we've heard a lot about, the live, work and play. It's not clear what proportion of workers will be there. In Ms. Loynes' evidence, she talks about the survey, the travel survey, which shows that 15% of trips are to work. And I understand that's a census survey. So that means 85% aren't. And all of those trips that aren't, and a number of that are, because not everyone will be employed in the Ohinewai development, will be on the expressway, and they will be travelling. And car dependency is an issue in New Zealand, full stop. But that's, to me, the NPS UD is looking for a reduction in carbon emissions, and it's defined a well-functioning urban environment as one that is seeking to reduce those. Creating. Oh, sorry.
You go on.
Oh, just a development where that's kind of the starting point. Seems inconsistent to me with that concept of the minimum requirements of a well-functioning urban environment as defined in the NPS UD.
So just stripping all that aside, the showstopper issue is really the residential component and the use by people of the motorway to go to Huntly to avail themselves of different services.
No, it's a bit more than that, sir. It's the direction that's provided by the NPS in relation to what it is trying to achieve around carbon emissions, greenhouse gas emission reductions, and issues like that, and the accessibility. So a range of accessibility isn't just about by car; it's also about other modes. That might be walking, it might be public transport, of course, and as Mr. Quo referred to, there are some challenges around providing a sustainable public transport issue, because for public transport to work well, it needs critical mass of people, really. And yes, it can be funded, and there's absolutely no question of that. But in terms of priorities, and where council only has so much money to spend on public transport, and it's going to be looking for areas where it gets its best bang for its buck, or where that demand is most. And you know, the more remote a site is, and the more you know, that makes it more difficult, because people will be going to different places. Some will be going north, as Mr. Fulton talked about today. Some will be going to Huntly. Some will be going to Hamilton, and issues like that. So it's the challenging issue where you don't have critical mass to make it work really well, and that, let's face it, there is a very viable alternative, which is the expressway that is right there, so that for people with cars, public transport is unlikely to be attractive. So that accessibility is not just about people with cars, it's about different social groups, as I understand it, and certainly as I understand it from the guidance from the ministry around that. It might be the elderly, the unwell, the unemployed, students, and things like that. So it's to me, it's the issue of, is it giving effect to the NPS? Is it a well-functioning urban environment, or contributing to it, or detracting from it? And how it lines up against does it give effect to the RPS?
But you don't have any, now that you've had a look at what's been put on the table, you don't have any objection to you as a planner, to the industrial component?
I certainly, I haven't assessed it independently, sir, and I just want to put that there. But certainly, in terms of the evidence, and the evidence that's provided by my clients' experts, is that those issues predominantly, not solely, but predominantly relate to the residential component. All right,
thank you. You've said, and I'm turning to the statutory documents now. You've said in your evidence that this proposal has not been planned for in the RPS and future proof, and you acknowledge the alternative land release provisions, but the extent of this just goes too far and should be planned for. That's the gist of that's what you said in your evidence, I think, didn't you?
It's probably not exactly how I said it in my evidence, sir. I think the issue is, it is of a scale, in my opinion, that warrants some considerations around alternatives, and not just alternative locations. I mean, we've heard quite a bit of evidence about alternative locations for this, but in particular, whether there are alternative development patterns within the proposal, whether they would work. And ideally, as I say, that would have been ideally done through a Section 32 analysis to there. But it is a significant scale, and it is a decision to me that it is important to get right. It is a not insubstantial development. It is quite likely, I believe, to lead on to other developments, certainly as signalled by Waikato 2070 and by indications by Ohinewai lands and things like that, that there is likely to be flow on. So that was really my issue, sir, was planning, ideally, yes, and looking at the infrastructure requirements, absolutely. I mean, I think that's front and centre to both the NPS and also the RPS, is ensuring that is adequately provided for.
If you look closely at the alternative land release provisions there, and I'll just take you through
Sure.
them, the context in which they are to be looked at. First of all, you've got the express provision which allows for the alternative land releases.
Yep.
And you've got your 6A principles. In that context, you look at the NPS in Policy 8, which says you've got to be responsive to development that is unanticipated. There couldn't be any clearer than that, and which is not in planning documents.
Yep.
Which you've got Future Proof 2017, which says the settlement pattern must be agile enough to respond to change. It also says that the economic development interventions are needed for Huntly.
Yes.
and you need to stimulate positive economic and social outcomes for Huntly. That's what it says.
Yes.
You got a situation where we've received evidence that nothing has happened by way of significant development in Huntly for something like 20 years. We've got a situation where the benefits have been estimated at 200 million per annum. If the site effects, the physical effects can be managed, isn't this proposal exactly what the RPS is trying to allow through the alternative land provisions?
Well, that depends a little bit on its how you interpret it against the various provisions and the development principles that are under there. I accept, and all the planners did at the planning conferencing, of course, that this proposal can come under the is under the alternative land release. My review of the provisions, and I agree with from my review, but I don't have the background that Mr. Tremaine has, is that the provisions for alternative land release, when you read them, primarily talk about industrial land release. And Mr. Tremaine, who's been involved in Future Proof for some time, was of the view that it was always anticipated that the residential component would be within the identified urban limits, and that the industrial component, that the alternative land release criteria were primarily around the industrial component. And that was my reading. I don't have the background that he has. I can't give you any experience on that. But that was certainly my reading, that there is a lot of policies or provisions around industrial and very little around residential, which tends to support that in my view. However, we accepted that at the planning witnesses statement, that we accepted that the whole proposal would come under this. Yeah, and it does need to be agile. I think my issues about planning is alternatives. You know, the question is, if something comes through here, does that obviate the need to consider it through Section 32AA? Or does that need to be done as well? And I guess the issue on that is really where you sit within relation to case law, as to you don't need to look at alternative sites for a plan change versus there are certain circumstances where that is appropriate. And my opinion was in there is primarily around this issue of, you know, there is significant public investment in this. I come back to a couple of issues, sorry, just on that, you know, and there's been a little bit of discussion about the water and wastewater servicing issue, and would it be any different if this growth was somewhere else? I don't know the answer to that. I think, to me, I had indicated that I would have thought that the starting point for that would have been to do a base case. What is the current situation? What is required, and what is that growth? And then, what is the cost of servicing in this area? To me, it's about understanding what are the alternatives. And, you know, an alternative may not have the same infrastructure cost. There's no question that resource consents will be required. There's no question that upgrades will be required. But what is the difference in terms of that? You know, the issue that I was concerned about, and I don't know the answer to this question at all, is the servicing strategy is servicing a very large area of, well, proposing to service a very large area of industrial land. Is that going to include a trade waste component that isn't already there that will be discharged to the Waikato River? I don't know those issues and things like that. So this issue of, you know, understanding alternatives and options, and what are the costs and what are the effects of that, are dependent on options and alternatives. So what I was saying in my evidence is it is significant scale. There is potential for significant investment, and that in addition to considering those issues there should still be an assessment of Section 32AA.
All right. Thank you. Mr. Tremaine has said, and I'm not sure whether we're going to hear from him, that phase 2 of Future Proof is to be triggered again. I think it's going to start either this year sometime or next year, to look at the corridor study and the NPS, the NPSUD, and I'm not quite sure whether that also included the Waikato 2070 study. So there is a study looking at development options around this northern part of the North Waikato. You've read his evidence, haven't you?
I have read his evidence. I can't say that I focused on that particular aspect of it.
Well, he has said that.
Yeah.
So what if, as a result of that phase 2 research or review, what if this area is identified for development in that study? This opportunity would be lost, wouldn't it?
Would this opportunity be lost?
Yeah, well, probably, not sure. Sleepyhead won't be, if this gets turned down, not sure whether they'll still be in the game. And by the time that study is out, and if it shows, yep, this is a development area, what I'm putting to you is that opportunity is lost.
If it is turned down and Sleepyhead choose to go somewhere else, then yes, this opportunity is lost. I guess. I don't know what the alternatives are. I don't know whether that would be, this is coming back to my consideration of whether there are other aspects. Certainly, resource consents have already been lodged to start the industrial component and start Sleepyhead's component of that. So the extent to which it would be fully lost, I can't comment on that.
Sure. Thanks, Mr. Mayhew. Thank you.
Thank you, Mr. Cooney. Mr. Mayhew, Mr. Cooney's asked most of the questions that I was going to ask you. Just a couple of additional ones. Do you agree that the only specifically directive provision in the RPS regarding urban development is policy 6.14a, particularly as it relates to residential aspects, insofar as it uses the word shall be in accordance with the indicative urban limits set out in map 6.2?
So just in terms of the objectives,
policy, I think that's a policy, but yeah.
Yeah, no, I understand that, sir. Sorry, I've just got the wrong piece of paper in front of me. That's not the right one too. Objective 3.12 relates to the built environment.
Yes.
While that doesn't use the words should, shall, consider, or any of those, it says development of the built environment occurs in an integrated, sustainable and planned manner which enables positive, including by. So I think that is, while it doesn't use the term shall, it is creating an objective that it expects to be achieved.
But that's a high level objective, isn't it? That doesn't specifically refer to you can go here, but you can't go there.
Yeah.
And the list of criteria is non-definitive. It says including by things like promoting and integrating and minimizing and anticipating and responding. That's not directive, is it?
And recognising and protecting.
Yes. No, I accept that. But is that do you read that to be along the lines of a King Salmon directive that says, I know it's not an effects-based provision, but King Salmon effectively said avoid means avoid. That's directive. There's nothing directive about this in terms of saying that development can only occur within a certain geographical area. It says that you have to give effect to, or you have to take account of these criteria.
Yeah.
And that's
Yeah,
the context
and
of the
there are
question.
a number of criteria, as you point out, Sir. So it is multifaceted, which isn't as direct as very specific. In terms of industrial, sorry, the provision. Sorry, I was looking here.
Policy 6.14.
Policy 6.14.
Which is about adopting the future-proof land use strategy.
Yes.
Subclause A deals with urban development. B deals simply with residential, but only in terms of numbers, and it's not geographically explicit. The rest of the provisions, with one exception, effectively relate to industrial land. So the only directive policy that I can, or the only directive provision I can find, and I don't know if you agree with this or not, you might be able to point me to something else, but it says that new urban development within, including Huntly, shall occur within the urban limits indicated on map 6.2, and map 6.2 is an indicative map.
Yep.
So even though that's directive, it doesn't set an absolute bright line test, if you like, on where the urban limits for Huntly should ultimately be. I accept that this is different from that.
Yep.
What do you have to say about that?
I accept that, sir.
Okay, no, that's fine.
And just in the joint witness statement, you'll be aware that the planners agreed that A didn't actually apply in this circumstance because it wasn't within Huntly, and therefore it was provided for by the alternative release criteria.
Right, okay, no, that's fine. I accept that. Thank you. Are you particularly familiar with the Mid-Waikato water and wastewater servicing strategy and its genesis?
Not particularly with its genesis, sir. I have read it. I can't say I've read it all. It's quite extensive, but I have read it and looked through it.
Maybe I can ask a simple question. It's not really this development that's the catalyst for the development of that strategy.
Yep.
Is it?
I don't know the answer to that question. When I look at it, I did wonder around that, but I assume that there are definitely other issues there. I mean, there are clearly non-compliance issues associated with Te Kalwhata.
I mean, it would be fair to say, wouldn't it, that strategy is going to pose a pretty significant, or finalising that strategy and implementing it is going to be a challenging exercise for the ratepayers of the Waikato district, wouldn't it be? Given what would appear to be, I mean, I've got some knowledge of the Huntly plant. I've got quite a lot of knowledge of the plant at Te Kalwhata and the challenges that have been experienced there for many years trying to get that, if I could use the term, up to scratch. They're pretty significant issues that this area's got to face and fund, irrespective of this proposal, I would suggest. Do you accept that?
I would imagine so, sir. I mean, I know you did ask some questions before about what it would, of council, about cost of moving into compliance. But yes, I think, compliance, we're talking more than compliance. We're talking,
that's fine. I don't need to take it any further.
So yes.
Thank you. You will have heard the evidence yesterday of Mr. Tupuhi on behalf of the Tangata Whenua Governance Group.
Yes.
And he expressed some real optimism about the implementation of this strategy. He said he'd been personally involved in the consultation. He referred us, and I'd need to check my notes more carefully to make sure I've got the place names right, but he said that there'd been a significant gain made at Meremere that he was very pleased with. There were plans afoot at Te Kalwhata that he had confidence in. That's my words, not his.
Yes.
And he was pretty confident that the plan would, based on its community and Tangata Whenua interface, would deliver good outcomes at Huntly as well. Does that influence your opinion about the the implementability of this strategy, and that ultimately a solution is going to be found and implemented?
No, look, I accept that a solution will be found and implemented. I mean, I think it's essential. I totally agree with that. I mean, listening to the issues of non-compliance isn't good news. I guess the issue to me is really around how it is funded, and is there, and provided that is funded and provided for, as you say, it will be a potentially significant investment. But if it's funded, then yes, it's an incredibly positive aspect.
I suppose, and I think, and you've made the point that they all require resource consents, and there's some uncertainty about whether they'll be granted and those sorts of things. But it comes back to my question right at the start, that based on decisions like Puki Coal, for example, it would seem to me pretty hard to conceive of an outcome of that resource consent process that didn't implement the vision and strategy. Would you agree with that as a general hypothesis?
I think as a general hypothesis, I mean, as I say, my issue with the Mid-Waikato servicing strategy is that there isn't any information around performance and understanding that. But I have no question that achieving that is technically feasible. Achieving what is required to be achieved is technically feasible.
And if this proposal, though, assuming it were to be approved, had requirements that said you can't go beyond the ability to service a particular stage until that infrastructure's in place, isn't the rezoning somewhat of a victimless crime in that regard? Because yes, there's some uncertainty that things may not happen, but if the result of that is that the thing that you're concerned about can't happen either, doesn't that put that issue to bed?
I've got just two responses to that. I think if you could put it to bed definitely, then yes, I think so. But the slightly more perhaps complex issue is the staged approach relies on different solutions. And I understand that, and I understand the rationale for it. And Dr. Hackle's evidence, she is significantly concerned about partial completion of the structure plan and the implications of that. So the first phase of the residential component, I understand, is to be managed or wastewater treated out of the Huntly plant, essentially as it is under existing capacity, and that future stages would look for the upgrade before they go. So there is potential, and I honestly can't tell you what that potential is, but that could lead to a partial development, that it might get to a certain stage and say, oh, we can't actually afford to fund this, it's not in place, therefore we have to stop. And whether that in itself would be a good outcome.
Okay, all right, I understand that point. Thank you. Thank you, Mr. Mayhew. I don't have any further questions. Thank you very much.
Thank you. Thanks very much.
I'm not sure what the appropriate order to ask this question of council for the Transport Agency and the council is, but is there anything that either of you need to address in relation to the questioning of the witnesses that we've undertaken in the last little while?
Just one thing, sir, in terms of the questions about policy 6.14 and the sort of prescriptive or directive aspects to that policy, I just note subclause G has a shall in it as well, and it's again talking about shall demonstrate consistency with the principle. So I'm not quite sure whether that's sort of helpful to answer the question, but I just noted that as well.
And that is noted. That was the one I referred to them with the one caveat, and that was the caveat that I was meaning, and it's the caveat that I mentioned when I asked questions of Mr. Oliver. So
my apologies, Sarah.
Point taken. But yes, I am aware of that sub policy.
Could I raise, Mr. Chairman, could I raise a point with Mr. Lanning and Ms. Hurd about
of course,
about the NPS, because I thought it'd be a better question to ask the legal people than it's more of a legal question, I think. You've got policy 8 in the NPS, which gives, gives a clear direction on responsive planning. Do you think policy 8 informs the application of the 6A principles? In other words, it's directing that there should be a broad, more flexible approach to the application of those principles.
I think that, sorry, can you hear me?
yes, we can. Thank you.
Sorry, just checking. I think that it's not just policy 8 in the NPS that you have to have regard to, it's also policy 1. So I think to elevate policy 8 over policy 1 in any kind of way would be wrong. I think that you need to see both of those policies in the context of the land release provisions in the RPS. And that's why I think there's quite a lot of consistency between the two different documents.
Thank you, Ms. Sheard.
Mr. Lanning? Thank you.
Is there anything else? I'll just do it one by one. Ms. Sheard, is there anything else that you want to raise with us?
Just that after hearing Mr. Lanning's opening comments and his legal submissions, I'd just like to put on the record that I agree with his comments in relation to, in particular, his statutory assessment and his analysis. In terms of the RPS covering the field, I won't belabor the point, but I did agree with his statutory analysis. And the only other thing I really wanted to mop up was that Ms. Loynes did refer to a strategic document that I don't think is actually on the record. It's the original strategic document in relation to the expressway, and just wondered if it'd be helpful for me to make a copy of that available to the hearing coordinator.
Yes, please. That would, if you could make that available to Mr. Fletcher, Mr. Bell, sorry, he can make that available to us.
Sure.
Thank you. That's all from you?
Yes, that's all from me.
Thank you very much. Mr. Lanning, is there anything further from you?
I'm hoping to escape answering Mr. Kearney's question, but he might not let me get away with it.
Well, I'll ask it for him then.
I still think, and again, this is obviously, as I said, that the interaction between these documents, the NPS and the RPS, is still something we need to think through. But I don't think my views change from what I said before, and that your role is to ensure, was to consider whether effect will be given to both the RPS provisions and the NPS. And I'm not sure whether trying to sort of interpret the RPS in a way that's different to give effect to the NPS is actually going to be a very helpful way of doing it. In my view, you're better to treat the two separately and say, you know, here's our analysis of whether we're giving effect to the RPS, and then here's our analysis of whether we're giving effect to the NPS. And I think you won't miss anything in that approach. I'm reticent to say that you should somehow interpret the RPS differently in light of the NPS. And again, I'd pick up and I'd agree with Ms. Sheard's comment there that, you know, where you still end up is with the need to contribute to well-functioning urban environments. So that takes you back to that policy 1. So I think, yeah, I think certainly my sort of advice to you, and not that that's my role, is to treat the two documents separately and ensure that effect is, you're considering whether effect has been given to both
But what about in the case that if in the hypothetical that one is inconsistent with the other?
Well,
if the reach of the NPS exceeds that of the RPS, such that the RPS is not giving effect to the NPS, then we can't take that approach, can we? Isn't your scenario predicated on the basis that they're not inconsistent?
No, no, I agree with you, sir. So at the end of my sort of two-pronged analysis, if you found that giving effect to the RPS was somehow not giving effect to the NPS, then clearly you still have to give effect to the NPS. And,
sorry, that's all I wanted to clarify. And we haven't made any such determination, but obviously.
No, and I don't. I think the other point there is that, again, I would sort of reiterate again that these 6A principles are fairly standard orthodox planning principles that do create quite a bit of flexibility, provided that those outcomes, those principles are you've been consistent with them. So they do create a lot of responsiveness within them anyway.
All right, thank you. No, that's helpful. Sorry, Mr. Kearney.
No, that covers it. I suppose I was really, and Mr. Berry can answer it, but whether the application of those principles is to be informed by the policy 8 direction there to be responsive. So that's really, and I think you've answered it from your perspective, Mr. Lanning.
Well, I would say all of the NPS potentially, not just that one policy.
Yeah, but the policy 1 that you've referred to, that's really an evidentiary matter on the merits of this proposal.
Yes.
Yeah.
All right, thank you, Mr. Kearney. Mr. Lanning, is there anything else that you need to address us on?
No, I don't think that there is, sir. Thank you.
All right. I'm going to say that the afternoon has been exceptionally well managed, because it's about half a minute to 5, and we're at the point where the case for both the council and the transport agency is finished. So rather than prattle on and run over time, I just think that the contributors today, it's been very helpful. It's been very interesting for us. Not sure that it's made our role going forward or our decision-making role any easier. And of course, we're not finished yet. But thank you, everybody, for their contribution today. Unless there's anything anyone needs to raise, we'll adjourn and commence again tomorrow at 9 o'clock. And if the panel could just hold on for a moment, please. All right, it appears there is nothing else. Thank you.